Okay.
And we are live, Mr. Chair.
Okay, thank you, Mr. Clerk. Good morning. I'd like to call this public hearing of the General Law Committee to order, the March 3rd public hearing. It's 10:01 a.m. I believe my co-chair will be joining us in a little bit, but I'm not sure if I see either of the rankings on yet, Mr. Clerk.
I don't see them either yet. Representative Bertigliano said he might be a little late, but he said he might be in and out.
Okay, and as we know, there are at this time of year there are a number of other hearings going on at the same time, and so we will, I guess, proceed. Number one on our list is Michelle Lucan from the Office of the Attorney General, and I believe she will be testifying with Cara Passero. Mr. Clerk, if you could let them both in, please.
Yes. Michelle should be in and Kara's coming in now.
Good morning.
Good morning.
Thank you for having us today. Good morning, Chairman Mahoney and Chairman D'Agostino, Ranking Member Whitghost and Rutigliano. My name is Cara Passero, and I'm Chief Counsel and Director of Legislative Affairs for Attorney General William Tong. I'm joined this morning by my colleague, Deputy Associate Attorney General Michelle Lucan, who is Chief of our Privacy Section here at the Attorney General's Office, and we're very pleased to testify in support of Senate Bill 6, an act concerning consumer privacy. Michelle will provide some additional detail on the Attorney General's position on this important bill. I'll let Michelle, if she is on here, take it away.
Good morning. I'd like to echo Kara's comments and thanking you all for giving us the opportunity to weigh in on this important bill today. Our office strongly supports this legislation. If passed as currently drafted, it will empower Connecticut residents with overdue rights over their personal information. It will also allow all of us to gain a greater understanding of the value and use of our personal data. These protections are crucial in an era of increasing reliance on technology and a proliferation of data breaches. We'd also like to recognize that the bill has benefited from the thoughtful input of various stakeholders, many of whom are on or are listening in today. And we'd like to highlight progress made in 4 key areas. First, the bill now provides that violations are per se violations of Connecticut's Unfair Trade Practices Act, or CUPPA. And we've maintained that it is critical for our office to be able to meaningfully carry out the law's protections when it's passed. The tie to CUPPA will enable us to do that. It will give us the ability to investigate potential violations in a thoughtful way and make use of a wide array of redress options, including penalties, but also injunctive relief where it's appropriate. Second, the sunset of the 30-day cure period is another crucial component. Without a sunset, our office's ability to protect Connecticut residents will be significantly hampered. And the sunset, in our view, it strikes a good balance because it will allow smaller Connecticut businesses some time to adjust to the law and get used to it, but also give us the ability to react when we need to address larger violations. Third is the requirement that companies honor global opt-out mechanisms. So without a global opt-out, consumers would need to identify which companies are collecting their data, an almost impossible task given the labyrinth of cross-company data sharing. And then they'd also need to submit hundreds or thousands of requests separately to each of these companies to exercise the rights under this bill. So requiring that that controllers honor universal opt-outs will ensure that all of us can easily and uniformly signal our privacy preferences. Fourth is the updated definition of sale in the bill, which now includes data exchange, not just for money, but also for other valuable consideration. This is crucial because dated conceptions of selling information simply do not reflect how data has become its own form of currency. So this expanded definition will ensure that large swaths of data transfers are not wrongfully exempted from the law's reach. That all said, we do continue to have some concerns about the many exemptions in the bill that could serve to dilute the effect of the law. An example of that is that the bill not only exempts financial information protected by the GLBA, but also financial institutions subject to the GLBA. And we continue to believe that exemption should be tied to the information these laws are designed to protect rather than entities as a whole. But overall, we view the current draft as a good foundation, and we would urge the committee against any changes that would weaken that foundation. Of course, we'd support efforts to strengthen the bill's protections further. And one area that will warrant for further discussion and careful consideration is whether the law goes far enough to protect teens as a group particularly vulnerable to harm from privacy violations. Once again, we appreciate the opportunity to support passage of this bill. Our view is that now more than ever, Connecticut consumers deserve greater control over their personal information. Thank you very much.
Thank you. And I'll allow others to go before I ask my questions, because as you know, I could probably ask a lot of questions on this topic. So I'll start with Representative Cheeseman.
Thank you very much, Chair Mahoney. Thank you for coming here today. I have a few questions. With regard to the global opt-out, my understanding is the technology that would permit that does not currently exist. And I find it somewhat concerning that we would be stipulating a requirement for something that's currently is certainly not possible. So I just wondered if you could comment on that.
Yes, quick comment back. Our understanding is there are mechanisms for this already. And so this is something that has already gotten a lot of attention and focus on in California. And the California AG's office has made very clear that their view is that global privacy signals must be honored. I do understand it's a newer area and some of this is still being built out. I also know there's a delayed implementation for this provision to account for that. But this is one of those areas that even from the time we were talking last year, so much progress has been made. And, parties who are a whole lot more knowledgeable than this than I am have really come together to make sure that when this law takes effect, it'll be ready and available. Tools will be there.
Thank you. With all due respect, I'm not sure I'm relying on the California's AG's office as the fount of all knowledge with regard to what is technologically capable. You talked about the sunset period for the cure and how that would help smaller companies. Again, my concern with all of the committees I sit on is the disproportionate impact this will have on our small and medium-sized companies. Particularly, I've seen the number, of customers reduced from 100,000 to 65,000. So again, what can you say that's going to give those small and medium-sized companies that are really the majority of companies in our state confidence that this is not going to be not only a financial burden, but a technological burden? We have seen our industries, particularly those who were shut down by the pandemic, facing so many issues. So again, I'd love to hear some reassurance from you as to why, particularly, maybe you apply the cure provision, you have a different sunset depending on business size or revenue, or there's a point at which over a certain number of customers. But this is of real concern to me. So I'd just like you to discuss that for me, please.
Of course. And I also would defer to Senator Mahoney on this because I know he has given a lot of thought and careful consideration to this issue. This is an issue we are sensitive to as well. And we agree that, we've had a lot of discussions over the years to ensure there won't be a disproportionate impact on small businesses. I think with respect to the threshold, there was a lot of thought given to what's an appropriate threshold for Connecticut as a smaller state than other states that have already passed this law. And so that was the reason for the change there. I think that will do a lot to soften the impact of this law on small Connecticut businesses. And then the cure period is designed to help small businesses have some time to adjust to the law. But I've also explained in the past that is something that's already built into our office's enforcement process to begin with. That's something we are sensitive to. We consider it when we are exploring potential violations. So this is an issue top of mind, but again, I know Senator Mahoney has given this a lot of thought and consideration as well.
Okay, thank you. I just imagine, if you're a medium-sized business and even if you have discretion on your punitive actions, being contacted by the Attorney General's office is not going to be something that's going to allow you to sleep at night. And many small business, we don't have legal departments. We don't have compliance departments. And I know this is going to be touched on later, but the effect this might have on store loyalty programs, that this may present an issue. And a lot of people really love those because I'm probably one of them when I go into CVS and I discover my bill's been reduced from $50 to $20. So again, how is this, people may say, oh, this is great. My personal data is going to be protected. On the other hand, I'm going to lose out because they've assumed I've opted out from everything. So, it's the law of unintended consequences. We want to accomplish really good things, but what's the fallout from that?
Mm-hmm. Another excellent point, and you are correct that I think there will be discussion on this later. I know that this is something that Maureen Mahoney from Consumer Reports has paid attention to in particular, but the goal is to be able to preserve those programs while ensuring there isn't any negative impact from further use of that information to your detriment. So, and I think the bill does strike a careful balance to that end as well.
Well, I've taken so much of your time, and I know other people have questions, but I just, I do have concerns about this. And again, with regard to data breaches, we have legislation that already addresses that. So I think to conflate the two is very misleading for anyone who might be listening. But thank you very much for your answers, and thank you, Chairman Mahoney.
Thank you. Senator Kissel.
Good morning. I won't, at the outset, I'd like to thank you, Chairman Mahoney, for all your hard work on this for years. And let's see if we can't maybe get some success this year. My question's really simple. GLBA, I just don't know what that means.
It means the
Good
Graham-Leach-Bliley Act.
What?
The Graham-Leach-Bliley Act.
And how would that?
It's a law that covers financial institutions and is geared towards protecting personal information that financial institutions collect and process.
This is sort of off the beaten track, but since I have you here, and I have mentioned this many, many times, I am one of the people that have been a victim. I think it was identity theft. I'm not sure. But all of a sudden, I had 3 credit cards, probably too many, and somebody was abusing them. And they also were able to abuse my debit card and wipe out my bank account. So the bank I took care of, got a new debit card, and just rarely used it. On the credit cards, when I called them up to have things stricken off, that was great, but it was like while I was in session. So imagine this happening right now. And so they would send me a new card. They took care of the charges, and then they sent me a new card via FedEx. And we were so busy in session, it was just sitting here literally on this dining room table, since now we have to Zoom from home. I didn't even open it up. And lo and behold, before I even activated that card, there were new charges getting put on that card. And I've told this story to a lot of people and they go, oh, that shouldn't happen. How could that happen without you activating the card? And unless it's an inside job by the financial institution, I don't have an answer to that, nor have I ever. I had to just stop all my credit. My credit's totally ruined. I'm slowly building it back up. But once these bad doers start messing with individuals, it's really hard for us to pick our way through and figure this out. Do you have any insights on how that could have possibly happened?
I have no insights on how that could have possibly happened, but I know it shouldn't have happened. So that is something that I would, contact the bank about to try to get an explanation. And I remember you mentioning this last year, and I had offered that our office as a resource. We have a consumer complaint center, and this is something our office does regularly on behalf of Connecticut residents. 2 other points.
You're right. Shame on me. Gosh, I don't know what I've been doing the last year, but I'll jump on that.
Please take advantage of our resources over here, because we have some really good folks in that unit that I know could help you get an answer about how something like that could have occurred. But 2 more points on this is, 1, it highlights what an inconvenience it is when your information is taken and exploited. And 2, it also highlights how this crosses over and could intersect with data breaches, because it could have been that your information was out there due to a data breach. And this bill will actually hopefully lessen the impact of data breaches going forward. There's a data minimization requirement, which basically says companies, you shouldn't collect data if you don't need it. And you shouldn't hold on to it for longer than you need to hold on to it for. And hopefully what that will do is lessen the amount of times your information will be compromised as a result of data breaches. There's also a reasonable data security requirement, which will hold companies to implement good data security practices that would hopefully prevent this issue as well. So a couple of comments in response, but please send us the information and we can try to get an answer on your behalf.
Well, thank you for reminding me. It's not that it was sort of in the back of my mind, and it was a busy year, but I knew our chair was on the. He actually solicited my input over the fall, and who knows? I just here I am today. Give my best to the Attorney General William Tong, my good friend and former tri-chair of the Judiciary Committee. And again, Mr. Chair, I really commend your hard work on this. It is not easy, but you got all the stakeholders around on the table, and getting the good feedback from folks like Representative Cheeseman. I'm sure we can fashion something appropriate for Connecticut, and yet still extraordinarily beneficial for both small businesses and the consumer. So thank you for you guys for coming this morning.
Thank you very much, Senator Kissel. I don't see any other hands raised, which means that now I get to ask questions. So I think that Senator Kissel, it's a good lead into one of the questions a few of the questions I was going to ask. So first, I think a lot has been made of the cost of compliance, but what is the cost of non-compliance in terms of what are the potential harms to our residents if we do not pass a law like this?
The cost is extremely steep. It'd be difficult to actually assign a cost to it because it's that high, is my reaction to that.
And so as the example of Senator Kissel is that lives are put on hold, credit can be ruined if there's identity stolen. And there are other, potential, the tracking from advertising, there are other potential harms, I would assume. I think you touched on it, but I did want to just go back to, in this bill, we have, we require data protection assessments and data minimization. Are those required in the other data breach laws?
Yes. So in Virginia has those same requirements, and so does Colorado.
Oh, I'm sorry. I apologize. I meant, do we have them in our existing data breach laws, or are those new protections that we would be creating to help prevent against potential data breaches?
Got it. Those would be new, and those are critical requirements.
Right. So the data minimization, then that would help to make sure that if there was a breach, it wasn't, it was minimal and less harmful, I would.
Exactly. And that's something we speak on very often too. One thing we always say is that is the single best step that businesses can take to reduce their risk for violations of privacy laws, whether you're a small business or a large business. Data minimization is something that you can do to really offset the risk of liability for violations.
Thank you. And I think, there was some talk about the cure period, and in a previous version of the bill, there was the instructions for a permissive cure. Is it necessary for us to legislate a permissive cure, or what is your current practice in regards to curing a minor violations, let's say?
Yep. So our current practice is to look at each investigation on its own facts. We consider whether the business is a small business or large business. That's a factor. And we very frequently will reach out to companies to ask for a response when we become aware of potential violations, to see what that response is. I think that's a common practice of our office, to give companies the ability to respond and explain their reaction to the complaint, or maybe we've seen a media report shining light on a potential privacy violation. So this is something we do very regularly, but it is not something that is a requirement in any other law that we enforce in our office. This 30-day pause where we would be hampered from reacting to a significant privacy violation. So that's the difference. It's something we do very often, but I'm not aware of any other area in our office where we have a 30-day cure period like this.
And that was going to be my next question, is how many laws have we passed that include a cure period? So I guess to your knowledge, there are no other laws that you are tasked with enforcing that mandate a cure period.
That's correct.
Okay. You mentioned on the privacy protections for children. I think that given the president's comments at the recent State of the Union address, this is going to take on new significance. So can you just talk a little bit about what privacy protections there's already the Children's Online Privacy Protection Act, but can you talk about how this goes further than that? And then you mentioned that it is an area that we should strengthen. So if you have suggestions for how we could strengthen our protection of children.
Of course. Yep. So we already have the Children's Online Privacy Protection Act. It's a federal law. It applies for kids 13 and under. And we've always had this gap for teens. And so this law is already has a good start to this. So what it currently provides is it says that companies shall not process personal data for targeted advertising or sell personal data without consent, where a controller has actual knowledge of or willfully disregards that a consumer is at least 13 but younger than 18. And that's really important. And there's been a lot of discussions at the federal level regarding COPPA about whether COPPA protections need to be expanded. COPPA protects kids 13 and unders, but the underpinnings are the same. And what I mean by that is COPPA applies to operators with actual knowledge that they are collecting personal information from children, but there have been a lot of concerns raised that that bar is just too high, and creates an incentive for operators to keep ignorant of ages. And so some of the federal proposals would move away from that actual knowledge standard towards a constructive knowledge standard. And what that would do is finally require operators to implement long overdue age verification systems. So merely posting an age limit and saying, kids shouldn't be on this platform wouldn't be enough anymore. if there's a really strong likelihood there's a whole lot of kids using that platform. Another goal is to ban targeted advertising directed at kids without parental consent under COPPA, which would overlap with the goal here for teens that I mentioned. So we're paying a lot of attention to this now. We're seeing all of these reports coming out about how much kids and teens have been harmed by privacy violations. And also, frankly, about how much money big tech companies are making off of kids' data. So this is a crucial area to look at. And I think what we'd want to make sure of is that this language here, this actual knowledge or willfully disregard language does require an age gate, similar to where this is headed for COPPA. Our view is that it does, and I think that's the intent. But going forward, I think it could also be worth continuing this discussion to see how we can raise the bar even further for teens. And I know that the UK has done a lot with this and implementing its age appropriate design code, which basically says these considerations should be included from the very start. And that's just scratching just the surface, but it gives an example of where this is trending and just the need for stronger protections going forward.
And so, please correct me if I'm wrong, but I believe the way the bill is written now, it would have, children would have to opt in. It's not banning targeted advertising to children. It's saying that they would have to opt in for targeted advertising versus for all adults, you would have to opt out, correct? So the default is for adults, you can provide targeted advertising, and then the default would be for children. If you had actual knowledge. Right. So if you didn't know the age, then you wouldn't, be required to get the opt-in consent. Is that correct?
That's correct.
And the way it defines targeted advertising, so if I were on a website, let's say, not me, let's say my son who is 15, he'll be 16 in May, but let's say he were on a website, targeted advertising, they would be allowed to advertise within that site based on his activities, but they couldn't use his activities to follow him throughout the web. Is that?
That's right.
Correct. So the
That's
way we
correct.
do. So we're not prohibiting a website, a Facebook or whatever from, if you were on, and I don't think kids use Facebook, but I'll just pretend, or not as much as adults do, but just because I think that's the example that's more common. But if you were on there where you have to put in an age, right, to create, or you don't have, but you put in an age to create an account so they know your age, they could still show you ads based on your activity on Facebook, correct? It's just
Correct.
They couldn't then follow you throughout the internet. So it's not prohibiting them from showing ads. It's just prohibiting the practice of sharing the data, beyond their walls, so to speak. Is
Right.
That's correct.
Okay. Thank you. I know, we're going to have other speakers, and I've looked through some of the testimonies. So I just want to get your feedback, because a lot of pain and care was put into this bill to make sure that, we want to protect consumers. We don't want to unnecessarily overburden, businesses or hospitals or nonprofits. So I'm going to go to, there is some testimony that I've seen that says that if this bill were in effect, we would not have been able to fight the pandemic the way we did, using the data for vaccines and so forth. There are two separate exemptions in this bill that speak towards the use of data for a public health emergency, right? And so it was so important, we didn't just have it in one place, we put it in two places in there. So can you just comment on your opinion on how it may have prohibited? And the other thing, if you could comment on, is that California already has these protections in place they, ran similar outreach efforts during the pandemic. So.
Right. I think this activity falls squarely within the public health exemption. And it's a good example of how this is a multifaceted bill, and it's well thought out. So I don't see how it would have prohibited any of those efforts.
Now, I think one thing that was brought up, and I, need to look in it further, but was that our definition of public health, could that be expanded to include community health and population health? Because again, there is testimony that it won't, the way the bill is constructed, it would prevent the outreach on social determinants of health or other things that came from SB1 of last year. And I'm sorry to spring that on you without the opportunity to really think it through, but it's just.
I think it's a good question. I think it's a good question for the committee to consider. I think just in general, we are supportive of concerns that are raised to this effect. So I think it's a good issue to take up.
Okay, thank you. And I'm trying to think if I asked you all my questions. Just how long would you estimate over the last 2 years? How many times would you estimate, or how many hours would you estimate that we've spent talking on this bill? And I'm just saying, not including, with the other stakeholders you've met on this bill.
We've definitely spoken a lot on this bill, and that is one of the reasons why we wanted to highlight the progress from last year's bill to this year's bill. I think the changes are very thoughtful, and it's been a product of discussions, not just between us, but with a lot of different stakeholders that have addressed these issues in a very careful way. And then one final comment, because I neglected to mention it earlier, just about, again, sensitivity to small Connecticut businesses is another one of the changes from last year's bill to this year's bill, is that there is now an exemption for payment card transactions. And to just explain that a little further, so what it will do is exempt, though I know that concerns have been raised in the past about payment processing and how does this affect small businesses. So the idea is if there's a single payment payment transaction and data isn't held or used for any purpose outside that payment processing, that is outside of the reach of the bill now. So it was something that was added to continue to try to be sensitive to small Connecticut businesses having to comply with this law.
Thank you for adding that. And you're right, there was a lot of back and forth, and they weren't the intended targets. It was made very, very clear. So thank you very much, Ms. Lucan and Ms. Passero.
Thank you.
Okay, Mr. Clerk, next is Scott Dolch of the Connecticut Restaurant Association.
Yes, he should be on now.
Hey guys, can everybody hear me? See me?
Yeah, we can hear and see you. You look sharp today, Scott. So, or Mr.
Sorry,
Dolch. So,
sorry.
please.
Sorry,
proceed.
good. All right. Good afternoon, members of the General Law Committee. My name is Scott Dolch. I'm the president and CEO of the Connecticut Restaurant Association on behalf of Connecticut's 8,500 restaurant and food service locations. I'm here today to address Senate Bill 6. Joining me today is Brennan Duckett, Director of Technology and Innovation Policy for the National Restaurant Association. Clerk, were you able to allow Brennan in as well?
Mr. Clerk, can we allow him in if he hasn't been allowed? He is on later on, but we'll allow you guys to testify together if that's
okay, Senator. Appreciate
it's great. 2 for 1.
I think I'm here.
All right, thanks, Brennan.
Okay.
I'll keep going. So The Restaurant Association supports efforts to ensure individuals can control their personal data. However, we believe this bill would have far-reaching impacts beyond what the committee intends. If the intent of the legislation is to protect Connecticut restaurants from the harmful efforts of massive technology and social media companies to control their personal information, it's important to understand that this bill, as drafted, would also drastically impact thousands of small businesses across our state. Businesses that have no interest or desire in controlling the personal data of state residents. For restaurants, it would also put an added burden on them, just as they are beginning to turn the corner from a global pandemic. As I sit before the committee today, there are many more questions about the impacts of this bill on the hospitality industry than there are answers. Restaurants in Connecticut range from small one-store locations with less than 10 employees to multi-unit owner franchisees of a national chain to Connecticut-based restaurant operators with several locations of 100 or more employees. Would all of these business models fall under the provisions of this proposal and have to comply? I believe that they would, but I'm not certain. Restaurants have many different ways that a consumer, as is stated in the legislation, can utilize their services, whether that is dining in at their establishment, ordering pickup, ordering delivery, reserving a table, booking a large party or event, scheduling off-site catering, and much, much more. Utilizing technology through the business website, third-party websites, creative apps, and/or QR codes have become the norm for our industry. Taken together, reaching 65,000 consumers, as stated in the bill, for a locally owned restaurant in Connecticut can and will happen pretty quickly. Once they exceed this threshold, it will not only add a new financial burden on these businesses, but will also add a new form of stress to an industry that is not in the business of collecting and processing personal data. Given that reality, my question is, do you believe your local pub or favorite restaurant in your hometown is collecting and selling your data? Is this who this legislation is intended to impact? The restaurant industry was hit hard, hit early, and hit enormously challenging for this pandemic. And we are absolutely still in recovery mode, if we've even reached recovery yet. We all know of a restaurant or two that closed during the pandemic, part of the more than 600 statewide. Without solid numbers of what the cost will be, how can we be sure passing this legislation won't force more restaurants to close their doors because compliance is just too costly? I ask the committee to consider the unintended consequences of this legislation and the burden it would impose on local hospitality industries currently fighting to return to full strength. Thank you for the opportunity. Obviously, Brennan represents national from a director of technology innovation policy, as I work closely, as you guys know, with the National Restaurant Association and with what the bills have happened in California, Colorado, and Virginia, but also what else is happening across the country. So Brennan can kind of talk to that if you guys have questions, but that's my testimony and happy to take any questions.
Great. I'm going to, again, wait till last to ask my questions. So I don't know if Brennan had wanted to say anything or if he just wants to respond to questions.
No, I'm just happy to respond to folks' questions.
Okay, great. Thank you. All right, Representative Ackert, followed by Representative Cheeseman.
Thank you, Mr. Chairman. And Scott, thank you. I did read your testimony and I appreciate you being here and weighing in. So now you mentioned that you get that $65,000 threshold number that could easily be for maybe for a larger chain, you're going to reach that pretty quickly or easily. And what other service areas do you think would also be impacted? Small, I mean, there are businesses that are small, but they are franchised that are in other service areas. What other areas do you see that will be impacted by this that may cost them some financial hardship?
Well, yeah, I think that it's a great question, Representative. I appreciate it. I think for me, it's still a lot of unknown. We know California passed this bill and they're still trying, they're the only one that's implemented it. Both Colorado and Virginia passed it, but they're still waiting till January. We don't know, as I talk to my peers in those states. The hospitality sector, as you guys know, as I mentioned in my testimony, technology, good, bad, or indifferent, has had to be used in this pandemic more so. I mean, a lot of people didn't even do takeout or using Uber Eats or DoorDash or all these delivery companies. And I think the big question I have is who's the controller and who's the processor as you read this. And I think, Senator Mahoney made a great point in the last conversation is I don't think you're intending on our industry. My biggest fear is if it does, and then we talked to California and, within their acts that are out there, they've stated that a small business could incur anywhere. They put $50,000 would be for a business of 20 or less to comply. And that number just scares the living daylights out of me. Now, because I don't think any of our industry is looking for this. That's my side of all this, because what defines, a consumer? Because if you say, oh, it's just a website hit, it's also them coming out. And as you guys know, We use QR codes on menus on our phone. That would be a consumer. You use Open Table, that's an outside company, but they host their restaurant for reservations. That would be a consumer, is how I read the bill. So I see that 65,000 representative get very quickly, not only for a large group, but even a small, very busy restaurant in the state can hit that number, very, very quickly. So it's a great question. And I think that's where it really is right now for me, is a lot of unanswered questions. And I don't want to add any financial burden to an industry that you guys all know have really faced, been the front lines of how this pandemic has treated them.
Thank you. Yeah. And as you know, Scott, there's times when, we don't intend a negative outcome of something, in our legislative, we want to create a positive. That's the goal. And I think that, Senator Mahoney's worked very diligently on that. The overall, the unknown, we do put something, what are we going to need to unravel, which may be cumbersome, but already have a negative financial effect on some of these small business sectors out there. So I thank you for your time, for being here. And Senator Mahoney, thank you for your work on this, and look forward to listening to more dialogue.
Thanks, Representative Ackert. Representative Cheeseman.
Thank you, Chairman Mahoney. Thank you, Scott and Brennan, for being here today. So my question for you, Brennan, how, if at all, does Connecticut's proposed data, this data protection law, differ from the laws that are currently in existence in Colorado, California, and Virginia, as far as you and your industry are concerned?
Sure. Thanks for the question, Representative. So there are a few aspects that differ, and I have just a few points, so folks feel free to interrupt if you have any other questions. But so obviously the scope was covered. So 65,000 consumers as the threshold would be the lowest for any law on the books starting January 1st, 2023. Both Virginia and Colorado have the 100,000 consumer threshold. And while California currently under CCPA has 50,000 as its threshold, when the sort of CCPA 2.0, it's called the California Privacy Rights Act, that was sort of their attempt at redoing CCPA the first time around. That comes into effect January 1st, 2023, and that'll be 100,000 consumers as well. And I think Scott did a good job of covering sort of why that 65,000 number sort of can come up quicker than folks might originally anticipate. I think the second one to point out is the effective date. SB 6 poses an effective date of July 1st, 2023, which is a much shorter compliance timeframe than California, Colorado, and Virginia provided to their respective businesses. California CCPA passed in 2018, became effective in January 2020, but enforcement was delayed another 6 months after that. And the CPRA has a very similar kind of timeline going into effect next year as well. Colorado passed their law in June 2021 and becomes effective July 2023. So that's a full 2 years. And some key provisions like the consumer's right to opt out of the processing of personal data for targeted advertising and sales, that won't be enforced until July 2024. And then finally, with Virginia, that was passed, I believe, in March 2021 and becomes effective January 2023. So that's kind of just gives you a little bit more of a longer sort of tail on being able to comply with the law. A few other things that I'd highlight, the controller processor dynamic that's at play in this bill is really good. We prefer that, especially when compared to California. Both Colorado and Virginia have sort of that dynamic at play, but we do still worry about the statutory obligations for downstream business partners, processing our customers' data. As a consumer-facing industry, we recognize that we're often the first touch point for collecting consumer data, but the lack of accountability for other players in the digital ecosystem is still concerning. I think Scott kind of referenced that a little bit too. And so ultimately the bill doesn't require processors or third parties to enact their own data protection measures. They're really only there to assist the controller. And so instead, it would be the controller oftentimes will be the restaurant. And those are the folks that will be held liable for a violation of the law, even if it's one of its business partners that mishandles consumer data.
And even if those business
Um,
partners are significantly larger organizations with greater resources.
Yes, that's exactly right. And so the last one or two more I think that I have just to touch upon with respect to loyalty programs, the savings clause for discrimination against the consumer, exercising his or her right to access, delete, or opt out is identical to Virginia and Colorado, which is great. But in this particular bill, this section goes further than either Colorado or Virginia by creating additional restrictions on downstream data sharing that enables a company's loyalty program to function in the first place. It's unclear to me why more restrictions are needed to govern the sharing of data between a controller and a third party within the context of a loyalty program, because consumers are already must opt in to participate. And so this affirmative consent, sort of from our perspective, should take precedence over any choice reflected through, a universal opt-out mechanism. Not only is this language generally kind of confusing and unnecessary, but it also takes us back to the same issue I just discussed, where liability would ultimately fall. From our reading, the bill would find the controller liable again if the third party managing the loyalty program were to use consumer data for a purpose outside of the program's contractual terms. And finally, I would just touch upon the notice and cure period as well. We do appreciate the inclusion of the 60-day notice and cure period and very much prefer, obviously, the enforcement authority to lie with the Attorney General's office and not with a private right of action. That said, this bill mirrors Colorado in that it provides the Attorney General's office with a lot of discretion around when a notice of violation is issued to a controller, which is based on the determination of whether a cure is deemed possible. I just, for the record, our industry prefers the Virginia model because the notice and cure period applies equally to all potential violations and was made permanent, as opposed to sunsetting, 1.5 years down the road, even if it is the 30 days. So I think those are my four kind of that I wanted to touch upon.
Okay, so I'm sorry, and you may not know this, and this may be a question for Chairman Mahoney. Who decides if a cure is possible, the controller or the AG's office?
I think that's a very good question, and I don't think that from our reading that the answer is in the bill.
Okay, thank you. Thank you very much for your time. Thank you, Scott and Brennan. Thank you, Chairman Mahoney.
Thank you, Representative Cheeseman. Mr. Duckett, Mr. Jolch alluded to an estimated $50,000 cost of compliance, but those are estimates that were put out in 2018 before the bill went into effect. We have actual data now. Can you tell me what your restaurants have seen as a cost in California? Was it anywhere near that?
So to date, compliance costs for small restaurants has really only been anecdotal, but we'll definitely try to send some hard numbers following this hearing. Obviously, you were sort of right in alluding to Virginia and Colorado. Definitely don't have any data yet because the bill hasn't become effective, but we can work on getting some numbers to you. Okay.
And then Scott, would it surprise you to know that I did reach out to, you had told me there are several different places who provide the websites for the restaurants. I don't want to name the company, but I did reach out to a company that does websites for 1,000 restaurants in Connecticut. And the average unique visitors to their website in a week is 450. So that would be 23,000 unique views in a year, which is well below. So the average restaurant will not be impacted by this. I don't know if you had a chance to reach out. I had asked you last year when I was thinking about doing this, and I reiterated, not to you, but to some of the other restaurants in Connecticut to find out, the larger groups, right, to see what their number of, because they're more likely, I think, a larger group.
Yes, Senator, I appreciate, your guys' effort in this. I guess I want to start by also letting you know, even last year with this, we didn't have much of a conversation. I think we can all agree that the last 2 years of my role has been, focused on just trying to help an industry survive and grant dollars. But I have talked to a couple different groups, and I think the one thing that's an outlier, even on that 450 or 23,000 number you provided, is even I've talked directly with who you're speaking to, that's just people going directly to their site. That doesn't include all these third-party groups, like I mentioned, like a Open Table, a DoorDash, a delivery. Even if you're doing like taps where you have beer up on the list and you have a beer menu, as you've probably seen, like that's housed by the different company, but it's for that restaurant. So who becomes a controller, who becomes a processor? So I think those are all the questions. And even if you say the average is that number, they're not going to touch it. There's still restaurant groups that I've talked to that are locally owned, Connecticut owned, that have 8 or 9 locations. They have one website with all their locations. They're going to easily hit over that number. We're going to see that. And then also, we don't know what the future holds with the technology piece. We know that QR codes didn't exist in 2018. They went away. Everyone's like, oh, what was that? And now everyone is using them. And then also the last piece, Senator, that I think was another point I tried to look into is we talk about Connecticut residents, and this only is targeting consumers that are Connecticut. But as I've talked to these companies, it's very difficult to know what is a unique customer and when they hit the threshold or not. And what I mean by that is, if let's say you take a restaurant, ABC restaurant in Milford, say we make up a restaurant, you look at it on your phone that night for the menu. Then you're at home on your laptop and you want to look for a reservation. Then your wife maybe looks at it on the iPad. That's 3 different IPs. So it would be showed as 3 unique customers, even though it might only be 1. So that's the other challenge. And also for Connecticut-based people that are using Wi-Fi in another state or in that restaurant, let's say they use the QR code and they're a Rhode Island resident in Mystic and they scan the QR code, it'll show that they're Connecticut because that's how the data is shown. So all of these kind of the questions, which gotten more into this data privacy thing than maybe I want to, as you probably know, right, Senator. But for me, at the end of the day, I think we've had this conversation. I just worry about any burden on any restaurant in Connecticut, even if it's less than 50 grand, if it's 5,000 or 10,000 to get into compliance, when I do believe that we aren't the culprits here. We aren't the ones that are out there trying to collect and sell data. We're just trying to serve food, and get people to come out and support in any way that we can. So I hope that helps answer your question a little bit more, because I think that's an ambiguous number of 450, because even if that's an average, the most popular restaurants, and there's a couple in your own district, I know that they're right on that. When they did it just on their own website hits, like we're right near that threshold. So I think that's, and I don't want to label one as well as either, but I've had that conversation to know that it will affect, the way it's written now, it's going to affect certain restaurants in Connecticut and not just the larger franchise and chains groups. It's going to affect small locally owned businesses that we all know and love.
Right. And Mr. Duckett, what have you seen? I mean, how hard has it been on the businesses in California? What complaints have you heard? I mean,
So in general, I can really only speak to just the broader litigation cases. I believe so far there's been roughly 195 cases brought to by the AG's office, and it's a broad swath of businesses that have had a suit brought against them. And I think the issues that the litigation focuses on, and I'm not a lawyer, so I'm going to be talking about this to my members next week with a lawyer who knows more than me. But my understanding is that the litigation gets after sort of the online privacy, sort of not being clearly using layman's terms language. That has been a common sort of litigation issue. But again, I'm happy to follow up with you more. And I know I have some more numbers and data that I can easily get you on sort of the trends that have been happening so far out there.
Right. Okay. And so again, understood, Scott, that you don't necessarily want to incur any additional unnecessary expense, but I think it's also, I own a small business as well, and I have a website. I think one of the things that is useful is for people to think about, are we putting our customers at risk, right? And so I my business is in an industry that was pretty much also destroyed by the the pandemic. So I completely sympathize. But I think there is a valuable process. In my business, I have 12,000. I looked on, and I spend $500 a month in online advertising. I have 12,000 unique Connecticut residents a year, so I wouldn't be drawn in. But I was once when I contacted a business that wanted to partner in California, and they said, well, you have to have your privacy policy up to date. So I think some of these things are good to think about, right? Because we don't want someone's credit card information be stolen or whatever. And again, we both use vendors for that, right? Who deal with that. So what I would appreciate then is if you were to come back, because I think you said that some of your larger restaurants are nearing the threshold, which means that they're not over the threshold yet, right? And so what are ways then that you could come back and suggest that the burden in with language to put more onto, I guess, your vendors, right? The websites you're hiring who are already complying in California, which is more strict than here. And part of the reason why I think they gave more time in California was it was brand new, right? Now, so many, there have been mechanisms developed to comply because of California. Obviously, Connecticut will be different, but it won't be more strict than California. 43% of web traffic is not for websites, but overall is, on WordPress websites. And there are plugins and other ways that do-it-yourselfers can comply now. So, but I would just, again, ask you, and I did reach out to a restaurant group out in California. It's a larger group, to find out what was their cost of compliance. They own 25 restaurants across California, somewhere in Hawaii. He couldn't remember because it was a few years ago, but and again, because it was new, it's probably a little more expensive then. But in terms of meeting with the lawyer, getting their website set up, he said it took him about 10 hours, and it was between $10,000 and $15,000 to comply. And he said he hasn't had to think about it, since then. But
no, Senator, I didn't cut you off. I appreciate it. I mean, I want to keep talking to you like we've talked, to try to find, I just don't want to put a burden. Even when you say 10 to 15,000, I think the question that I said, the 65 number was just on their own Google and website hits. Like, with the way that I also read the bill is the other ways that you can see the restaurant through the eyes of their third party still makes them the processor. Like Open Table, when you go and you make a reservation at a restaurant, it's not on that web page, but it's I would think that the third party would say, well, that's their business, that becomes their consumer. So, and you look at some of these restaurant groups, especially in our state, I've seen some of our best restaurants, have 10 to 15,000 unique reservations driven in a year. So that would add that up. So those are kind of more of the questions that I want to keep trying to, but even that 10 to 15,000 number, I would ask that to the committee, is saying, yes, there's always ways on privacy policies and making sure. And, I think the restaurants should be leaning towards the third party groups to make sure that that's what they do for a living. That's not what these restaurants do for a living. They would hopefully work through that, and we could make sure there's protections and language for the Connecticut consumers. However, I just think the financial burden, I think concerns me. The legal, potentially having to do, compliance sites, other things, other companies that are out there that are going to come to our groups and say, hey, you're going to have to do this. Here's a $10,000, we'll give it to you. Like that's not what these restaurants need right now. I think that would be the other side of it too, is, as I just told the governor, I'm here at the Argoat Stadium. I apologize for being late, but as much as we see crazy busy restaurants right now, they're not open Monday, Tuesday, Wednesday because they don't have staff. And they're also, their food costs are about 60% higher than they were even 6 months ago. So their margins are gone. So I just think that, like anything, on the flip side, as I try to talk to finance and try to find some sales and use support tax, like every little bit helps, but every little bit also can hurt. So that would be my other comment to the committee today, that as you guys look at this and know that I don't believe that we are the culprits, and hope that it doesn't have really any impact on our restaurants in Connecticut.
again, I've said that would be an unintended consequence. So I'm trying to work with you to make sure. I do have another question. You said, how many reservations diners does an average restaurant see in a year total?
I haven't pulled up. I've used open table data for every other reason during the pandemic. I have, and that's one. So that's one of like resi. So that's the other thing too. Our industry has probably 7 third-party companies that they work with in one time, and that could be reservations, all the different delivery, local delivery, like Dine in Connecticut or Shoreline Menus, but also they have to have the bigger guys as well. So you're going to have, and I think that's the questions I started to get back from these restaurant groups is, that's my fears. I don't know what the average is for that one reservation app that has been used, but there's also another 3 that they might be using as well. So I'm just saying is on a high end, I reached out to one of the busiest full fine dining restaurants, and they said they can have anywhere between 10 to 15,000 reservations that are made in that annual span of what that defines the consumer. And that's not their website. So that's why I look at their hits and then trying to get definitions and defining, when do they hit that threshold? When do they have to actually start being in more compliance than maybe just putting a privacy policy up on their website? When does it start to become a financial burden for them? And I do think the more that I talk to some of these groups, yes, some of our locally owned 3 or 4 Connecticut owned businesses are going to hit it because our industry is driven so much by data and by technology, by going out and trying to attract people to their business, because we're a forward-facing, consumer-facing business. I could get more data center. To your point, though, I will continue to ask these questions to see where that threshold and when they're going to hit it.
Yeah, if you could get actual data, that would be great. Mr. Duckett, how has this impacted? I mean, obviously, it's in place in California. You're a national organization. How have they dealt with the issue of using Open Table or other sites out in California?
So it's a good question. California, and I kind of hinted this earlier when I was going through the controller versus processor dynamic. California has been and continues to be sort of the Wild West with those third parties because, again, as many of these bills are drafted, there's no real liability for processors there is no sort of processor designation in California. So it's just third parties and service providers. And they're, once again, really not on the hook. So from our perspective, California is sort of the worst model, unfortunately, to think about that sort of question from, because, and we've heard stories of sort of big companies, basically saying we don't fall under the definition of service provider within this context. So therefore, we're not going to assist the business in California's case with sort of their statutory obligations when it comes to helping consumers access their information. So that's kind of why, again, and the Connecticut's bill is good in that it sort of, I think, boxes in companies better, and so at least sort of there's more clarity with who is what. Although, to Scott's point, I think it becomes messy when you go to a resi first, and then sort of they share the data with the third or with the restaurant, and I think that's where the waters get really murky. And sorry, Senator, just I did some digging on your previous question to me about the sort of triggering actions of litigation. I just found a couple more things. So the 4 sort of main aspects of what litigation has been sort of pursued in California so far has had to do with around a quarter of them have been around the privacy notice, a little less than that with data sales and disclosures. Most of them have been done with respect to data breach, which isn't really surprising, right? And then a small sliver has to do with specifically the data rights and requests, just to add a little more color around my previous comment.
Great, thank you. And again, my assumption is on the data request, right? The right, is the access to data that's collected. Most restaurants aren't saving that. So with the data requests, that wouldn't really fall. Well, the response would be, we don't have that data, I would assume, which in most cases will be the truth. And then the other is, if you're using Google Analytics, then you just have to provide the link. Google has made it, available for people to comply. And that's really the main reason most small businesses and others are controlling data is through the use of Google Analytics or something else like that on their site, another analytic program. So I do have a question. If you could just look at the loyalty program language, obviously, and come back. We're going to hear about that from the retailers, although this language was supported by the Hospitality Association. But if you can just, again, come back to me and figure out what would make it more workable. Again, we all like loyalty programs. We all free is my favorite flavor of anything. It's my favorite flavor of beer. So, we don't want to impact them negatively. So if you could come back, I would appreciate that.
Senator, real quick, what was the association that supported it? You said the hospitalities?
National, yeah, it was with the hotels. I have to, they sent me a letter of support, so I could forward that to you.
Yeah, that'd be helpful. Thank you.
Okay, are there any further questions? Okay, thank you very much.
Thank you, guys. Thanks, everybody on the committee.
Thank you.
Next, we have Erica Dahl of Find Help.
Good morning. How are you?
Good morning, Ms. Dahl.
I apologize. I'm in a medical clinic, so I have to wear my mask, but they've given me an exam room, so at least I have some privacy, which is what we're talking about today. So I appreciate your consideration and patience this morning. My name is Erica Dahl. I'm presenting testimony on behalf of Aaron Gray, who is my company's CEO. Our company is called Find Help. We're formerly known as Aunt Bertha for social services in the United States. We have over 9 million users. We have submitted Aaron's complete testimony for the record. Find Help is a public benefit corporation. We're based in Austin, Texas. We're proud to say that we've earned the trust of more than 430 clients, from state governments to health and social service organizations, including many that do business here in Connecticut. Regarding SB 6, we're here today to urge you to consider including language in this bill that establishes specific safeguards for what we call HIPAA adjacent data produced through the access and use of social services through closed loop referral management systems. We believe Connecticut is exactly on the right track to protect individual privacy issues, but we do believe the committee should consider expanding its focus to include data created through the access and use of closed loop referral management systems like Find Help's platform, where we can serve. So many of us, and I did this today when I walked into my medical clinic, are aware of the privacy protections that guide handling and storage of medical information under HIPAA. But such protections for an individual's interactions with social services are currently unclear and ambiguous. This HIPAA adjacent data deserves further consideration and should be protected with greater care given its sensitive nature. Most social service providers are small, community-based organizations that provide critical social services to people in their time of need. Unfortunately, community benefit organizations are not covered entities under HIPAA, and therefore they are not subject to the same privacy protections. Also importantly, there's often a stigma associated with needing social services, and we are here today to encourage you to acknowledge the existence of this stigma and respect consumers' rights to privacy as they access social services. We've all been there. We are in some of our most vulnerable moments, especially during the pandemic. Many people needing services are newly unemployed, survivors of trauma, ex-offenders trying to re-enter society, or parents helping their struggling teenagers. People expect this deeply personal information to only be visible to the people they trust and people they know. Connecticut's work on consumer data privacy makes it a leader in this issue space, and there is a need for additional safeguards to secure this HIPAA adjacent data in this bill. It's readily apparent because there are broader implications of coordinating care without abandoning the rights of individual privacy. Find Help has helped millions of people using a model not hindered we support efforts to establish safeguard additional protections regarding development and operations of closed loop referral systems in Connecticut. We hope the committee will work to adopt additional language into SB 6 that protects the HIPAA adjacent data for some of the state's most vulnerable populations. We believe such efforts will be emulated in other states. We hope Connecticut asserts itself as a pioneer in this emerging regulatory sector, and we stand ready to assist the committee in developing legislative language to protect Connecticut's residents' personal data privacy interests. Thank you so much for your time today.
Thank you. Are there any questions? I don't see any hands raised, so I'm going to start asking questions. And if anyone raises their hands, then I'll recognize someone else to ask you a question. Can you just explain exactly what is a closed loop referral and how that works?
Absolutely, and thank you. And I know that there was some language that I shared. This is my CEO. He founded our company almost 12 years ago. He is a developer by training. And so Find Help is a network, a nationwide network. And if anybody is interested, you can go on our public website at findhelp.org, which is free for anybody to use in the US and Puerto Rico. And you can start searching for low and reduced cost and free social services in a variety of categories. So if somebody is looking for rental assistance, they're looking for a food pantry, they're looking for suicide prevention services, mental health counseling, it runs the gamut. We have listed over 550,000 different services. We populate the network ourselves. We have 60 data folks on our team that do this. It's updated regularly. And the idea of the closed loop is that we know there are a lot of folks in the social care service space, in the medical space, that are working to help people. And I worked in the healthcare field for 10 years previously to coming to Find Help. We certainly had a lot of folks that we called our frequent flyers in our emergency room at our trauma level 1 facility. And our physician partners would say, we've done everything we can on the medical side, but clearly this person is housing insecure. They don't have access to the right foods to control their diabetes. So they're coming into the emergency room. We have to find a way, of course, now we call it social determinants of health, to address those issues. And we know long-term, it's better for the patient and the consumer, and also, of course, for the community. And hopefully there will be a reduced cost that comes from that. So the idea was that we would give, my community relations department would get a sheet of paper to our physicians who would say, it appears you have other needs, here's the paper. And then, of course, most times that person would leave and they wouldn't be able to make the connection. So the idea of the closed loop is that we have our network, anybody can go on. The 430 customers that I mentioned, 200 of them are hospital systems, 100 of them are health plans. They're using case managers and social workers. They're using the Find Help network to make those social care service connections. And then they're closing the loop by being able to track that those referrals are connecting to their patients. And so it's a new innovative way of connecting people in need to social care services, but that privacy element is missing. And so something that's been very important to our founder, and he had, his story really is that his mom, when he was 17, came down with a very debilitating brain disease. He had to become her legal guardian. He grew up in Buffalo. This was 30 years ago. He was busy getting on the phone looking for resources for his mom, and it was very difficult. And so this became his life's work. So he went to public policy school. He went to work for a consultant who was trying to improve eligibility in the Texas Health and Human Services Division. And what he realized was there were some gaps, and he was hopeful in the private sector and with his personal background that he could find a way to help improve the safety net. Privacy became a very key issue for him early on. And so built into our system is that whenever a referral is made, we ask if they're using our free website, findhelp.org, or if a social worker or care manager through one of our customers is referring somebody, every time they must ask for individual consent, may I share your information with this community-based organization so you can get connected? Because the idea is we believe it should be different than HIPAA. I'm here in the medical clinic, something happens. I want everybody in my medical team to know my history so they can help me. But with social care service, if I'm asking for help for a food bank, do I really want that in an open network where others who have access to the network can see my referral history? And we believe that social care services are different and that the consumer should be able to control their own privacy and they can opt out at any time. So if you were to go on findhelp.org and find a resource for yourself, you would experience that informed consent. And while some will say potentially they believe that's a burden, we've had 9 million users over 12 years, and we believe it actually offers additional protection and validation to people when they're using the site or someone is using it to navigate on their behalf, that their information is private and will only be seen by the provider that they have given that information to. So I hope that's helpful.
Well, that's very helpful. I do have a question on, so someone goes into your clinic and you determine maybe they need food and rental assistance. And so you're going to go in, or let's say you're going into a hospital that's a client, one of your clients, right? And they're subscribed to your system. So they go in, their patient is seen as determined that they need some food assistance and rental assistance. How do they get the consent before sending that request?
Yes, so that happens through, if it's through one of our customers, Hartford Healthcare, Trinity, they are clients of Find Help. Their case managers and social workers will take them through the process.
Okay. And so they're in effect submitting the form with them, or
that's right,
walking them through submitting the form online.
That's right. It's all done. The network is completely online, and it's the same network, but with our customers, it's white labeled. So it doesn't come up as findhelp.org. It comes up as Hartford Healthcare or Trinity, but it's powered by the Find Help network. And it is the same privacy consent throughout the network, whether you're using it on your own in the privacy of your own home, or whether a case manager or social worker is helping navigate you. You can also, if you had somebody in your family who you knew needed help, but didn't want to share that or was refusing to look for themselves, you could navigate for them, and then you could send them links to the referring agencies to say, I have found something that I think could be helpful, and then they can take it from there, and then they can offer their own individual consent. There are others in this space that adopt an all-in consent. And so in order to search for services, you have to provide that all-in consent, and you don't know the breadth of the network or where your information is going, and you don't have a way to take away your permission. And so the Find Help model is very unique, and we are working hard at the state and national level to raise awareness of the need for privacy protections around social care referral networks. So we really appreciate the time today to be able to share with you this information. And I think the next speaker, John Stephen, is an expert in this area, particularly in the state of New Hampshire, which is really leading out on this and has some model legislation that, if this was of interest to you to pursue, I think could be a helpful model. You wouldn't have to start from scratch.
No, I appreciate that. And so from the sounds of it, sounds like, you're already a way higher bar than what our bill is an opt-out, yours is an opt-in for the sharing, whereas so our
specific
model,
to social care. That's right, just for social care navigation, because this is such highly sensitive information.
Okay, great. And do you know, and I can ask the next speaker, so I apologize.
No, please.
Do you know if you currently have any, are working with any partners in California, since that's the only state where
yes,
the data privacy is currently being enforced?
Yes, we are in conversations with partners in California.
Okay, great. And I'll ask just to see if that has been a barrier there, but it sounds like since you already have a higher bar than is envisioned, that it wouldn't, these privacy protection laws wouldn't be a barrier to your service at all.
We have not found that, and we know that because California has been on the forefront, obviously, with their general consumer privacy efforts, and previously coming from Find Help, I spent time at a company whose 50% of their revenue was based on doing business in California. And we had to make the changes in order to comply with California specific privacy, upping of the bar of privacy protections. We were able to do that. We know that our customers in California saw that as a benefit. And so we made that investment, and we did business in 22 states. Ideally, we'd love to see something on the national level around this. I think we all would.
Right.
And I do participate in a lot of policy state groups around privacy in general. I was just in DC yesterday having conversations with a privacy expert there. It's a slow go, as we all know. And so really with the states being leaders and having someone like California and now Connecticut looking at what they can do to take the lead, I think it's important, and consumers don't want to wait. And the previous speaker talking about his own identity theft issues, I have been there myself, and it is expensive. And I think people, there's a lack of trust in government generally. And so this idea of being able to present that we are taking steps is really important. And at Find Help, we represent people in their most vulnerable time of need who are looking for free and reduced cost services at the local and state level. And so then to have a potential concern about their own information getting into the wrong hands adds insult to injury. So we're proud to be a leader in our industry in this space and in this conversation. And again, we just really thank you for taking the time to consider this additional component of the work that you're doing.
Thank you very much for your testimony.
Thank you, Senator.
Okay. All right, Mr. Clerk.
Yep. Up next is Jonathan Stephen.
Okay.
Thank you very much. Thank you, Chairman, Senator Mahoney, members of the committee, honorable committee. And I feel honored to testify today. My daughter went to Trinity College and worked for Senator Hartley, I think it was, and one of the greatest experiences she ever had. So my name is John Stephen, and I was a former secretary of HHS in the state of New Hampshire, and also overseeing Deputy Commissioner of Public Safety, overseeing state police, motor vehicles. And in my past life, I'm an assistant attorney general as well. So I have a law background, but I've been working with Find Help nationally in states of California, as you said, Senator, and also working in Florida, Nebraska, Virginia. Other states are looking at this issue right now that Erica has raised. And we didn't see this issue raised specifically in Senate Bill 6. We wanted to bring it to the committee's attention because this Senate Bill 6 is such a great foundation. And what you're doing reminds me of the driver privacy laws that I actually helped New Hampshire enact back in the late 90s. Very similar, where large companies were selling personal data and making lots of profit off of individuals without consent models, proper consent models. And so what Erica talks about is really that's what's growing in the industry across the country today in the social service area are these closed loop referral systems where companies are keeping lots and lots of data on very personal, sensitive information about families in need. And that consent idea, Senator Mahoney, that you mentioned, there's an individual single consent they're using in the industry that actually will say to someone, if you consent to having your information in this database, it will be available to the entire network. And what that person is doing is that person is opting in, and that person has the right to opt out at any time. So really this legislation wouldn't cover that per se. But what happens is during the time of need, during the time when they're so desperate and absolutely need help with maybe food, transportation, domestic violence, any substance abuse issue, if there's a network out there and these companies are putting a network together of social service platform, individual companies, you could be your community action agencies in your states, nonprofits can be part of this network. And then those individuals that work for those nonprofits can then get access to this information and know who is asking for what services at any time in need. And what the Find Help model is based upon an individual consent on each instance of a referral. The individual the person knows at all times who is looking at their information. And in HIPAA, that is controlled under the federal laws because it's medical information. When you start putting information into the social service area with these nonprofits that involve personal privacy, information about individuals that are asking for help, that's a whole different ballgame. And that's why we're here today, to basically ask this committee to consider looking at that area. And we are working today in my home state. One of those industry companies moved forward in the state of New Hampshire, and the legislature found out that that single consent model was happening. They were beginning to build a database, and the legislature immediately intervened, put a stop to the contract, and basically put a study committee together that worked all summer on this issue, and is now beginning to enact legislation that just passed the Senate last week.
Excuse me, Mr. Steven, you're the 3-minute mark. If you can start wrapping up, please.
Be happy to help you in any way, and I am done now. So thank you very much, members of the committee.
Thank you very much, Mr. Stephen. Are there any questions from members of the committee? If not, I'd like to ask a few questions. So you're doing, with Find Help, you're doing work in California. Has the California Privacy Act inhibited your ability to connect people with social services in any way?
Not at all. And again, the issue though in California and these other states, that's why the New Hampshire law is going to be very important. There is no national benchmark parameters, safeguards here in this area. California's strict as they are. This is a gap in California, and the legislature we're working with there knows this. And it may be addressed in the next session, but at some point this is going to be addressed in all states, because you're going to start to see a growing trend of these databases forming, and they're trying to help people, but there are areas where industry is using a standard, and they tell right up front, we are able to even sell your data. And that person consents to that at the beginning. And from there, they have no idea where this information is going and who it's being sent to, including in California today.
So, and you mentioned so that there are systems, not yours, but that are a closed loop referral system that will then sell or not necessarily, I shouldn't say will, but can sell the data?
They ask for a consent up front, and in the consent form, it says, we have the right to sell your information. And you are asking for help, and you just sign the form electronically, and you don't even consider that issue, correct?
Right, that does sound troubling, and that someone is at their most vulnerable point and needs help, and in order to get the help, they're giving permission to the sale of their data.
Yes,
you mentioned some of the referrals may be for domestic violence or other issues. It would seem that if that data weren't protected, that there's a potential real safety risk to someone requesting, and that we've passed laws where with insurance you couldn't give information about the appointments to the other spouse, right? Because of that. And actually, it's interesting. Sometimes we pass laws on theoretical, and then sometimes it becomes real. When I had a friend who left an abusive marriage, and she told me that she had a bad feeling about not going to a medical appointment, and she told the doctor said, "You'll be safe. I wouldn't worry." She said, "Well, I don't feel comfortable." And the doctor called her back after and said, "You were right. Your ex-husband was waiting for you outside of the appointment." So I guess that would bring up the point that does this create then potential vulnerabilities if we aren't treating this data with higher safety?
You're absolutely right, Senator. If it's HIPAA controlled and the entity itself is run by the HIPAA regulations, I'm not as concerned. It's when it gets outside of the HIPAA framework is when, yes, that risk can absolutely be prevalent. And it would be something I know that members of your committee would care about deeply, because that's a risk for anyone.
I think you bring up a good point, that there is data that's already regulated and treated with more care, right? It's regulated federally. So we've exempted that data, the HIPAA data. Now, in California, I believe that their privacy, it's just a data level exemption, so they don't give an entity level exemption to any entities that collect HIPAA data. Has that inhibited in any way your ability to provide services out in California?
No, it hasn't. It hasn't.
Okay, thank you. I'm sure I'll have other questions that I'm not thinking of now, but I appreciate you taking the time to come.
And I will be
testify.
submitting some written testimony anyways, Senator, and we'll be glad to help the committee in any way. Thank you.
Great. Thank you very much. Mr. Clerk, I believe next is Scott Copson.
Yes, we should be in now.
Great, thank you. Chairman D'Agostino, Chairman Mahoney, members of the General Law Committee. Thank you for the opportunity to testify before you today about SB 6, an act concerning data privacy and online monitoring. My name is Scott Hobson. I'm the Assistant Vice President of Government Relations for Big I of Connecticut. Founded in 1889, Big I Connecticut is a statewide trade association representing independent insurance agents and brokers. We believe independent insurance agents serve customers best with trusted advice to protect what matters most. As currently written and as a number of speakers have mentioned and discussed, SB 6 contains an exemption for data collected pursuant and in compliance with the GLBA. We would submit that this exemption should be expanded to an entity level exemption for entities that are subject and compliant with the GLBA. Independent insurance agencies are subject to robust data protections and regulations already. The GLBA, of course, being the most prevalent one. And of course, the two data breach notification law, the data breach notification law recently passed in Connecticut, as well as the law providing incentives for businesses to adopt data security practices and procedures. In addition to that, independent agencies are routinely subject to fairly robust contractual obligations to protect consumer data. These are typically written into agency appointment contracts with insurance carriers. They're written into our business insurance coverage. They're written into the errors and omission coverage commonly, and they're written into cybersecurity policy coverages that most or many of our members have. So this sort of constellation of regulations and requirements puts independent agencies in a heavily regulated space in a way that we believe very strongly protects consumer information and consumer data. Therefore, we believe that a GLBA exemption, an entity level GLBA exemption, would be appropriate for our industry and for our members, again, reflecting the myriad of protections that are already in place and the kind of unique business model that our members operate under. So with that, I'd welcome any questions that the committee has.
Thank you very much for your testimony, Mr. Hobson. Are there any questions? I don't see any hands raised, so I'll ask you a question and see if anyone raises their hand. You mentioned that you are already tightly regulated. Can you give an example of what are some of the protections that GLBA puts on the data that you are handling?
Thank you. It's a great question. And I do want to just thank the committee for addressing this topic and being, giving folks the opportunity to air our concerns. As it relates to independent agencies, the GLBA broadly requires us to adopt data security practices and procedures that are reasonable. I'm not, by any stretch of the imagination, expert on this, but this would include, making sure that you're, doing risk assessments of your own sensitive non-public information as an agency, risk assessments of those vendors that you're working with potentially, ensuring that you have reasonable safeguards for your data, so data retention and disposal policies. That would also include things such as the use of multi-factor authentication, These are not specifically spelled out in the GLBA, but these are sort of considered industry standard, and that's what's widely employed in our industry.
Right, thank you. And so, in essence, then some of our requirements would be redundant, right? I mean, we talked about the data protection assessment. You're already doing a risk assessment, and then you have the processes in place for ensuring that you're protecting the data.
That's correct. Yeah.
Okay, great. Well, thank you very much for your testimony. I don't see any further questions, so we appreciate you taking the time to come testify.
Thank you very much. I appreciate the opportunity.
Next, Christopher Gilrean.
Thank you, Chair Maroney, Chair D'Agostino, members of the committee. My name is Chris Gilrain, representing TechNet. We're a trade association made up of a wide array of innovative companies, from startups to household names in fields like IT, e-commerce, cybersecurity, autonomous vehicles, many more. First and foremost, I would like to express TechNet members' appreciation for the level of transparency and stakeholder engagement that's gotten into the development of this bill thus far. It's been truly a deliberative process, and our members hope to be engaged as this discussion continues. Ultimately, TechNet members' goal is a federal standard that provides all Americans with clear data privacy rights and responsibilities, and we are putting a significant amount of time and resources into that effort. And while that may have gotten a slight shot in the arm after the State of the Union, we understand that states nonetheless are going to push ahead with their own standards. That being the case, we do hope that states will consider as a default interoperability with other state models, clarity and certainty in statute, and enforcement that prioritizes compliance as opposed to retribution or frivolous legal action. On the interoperability front, we have to say SB 6 gets very high marks. It is really natural for states to want to put a unique spin, particularly on an issue of national importance, but every new wrinkle that's created can create uncertainty for consumers and drive up compliance costs for Connecticut businesses. And with few exceptions, SB 6 really reflects a strong understanding of that. Most of our recommendations are going to fall in the category of clarity and specificity and enforcement. For example, on the specificity front, the bill includes a pretty strong and specific definition of sale, but it does include language that considers the exchange of any valuable consideration as a sale. While we can all recognize a sale when money changes hands, it's going to be more difficult for companies to understand what might be considered an exchange for valuable consideration. This is the kind of ambiguity that could lead to unintentional violations, leaving holes in the protections that this bill is trying to enact and opening up companies to potential liability for unforced errors. On the enforcement front, we strongly support the Attorney General enforcement that's included in SB 6, but we would ask the committee to consider removing the sunset date on the right to cure. This new privacy regime, no matter how well constructed, will affect a huge swath of the Connecticut economy, many of whom were not involved in the stakeholder process or don't have on-staff compliance attorneys. This is complex stuff, and we know that it won't be static. This is going to change even 18 months after the enactment date, and companies should have the ability to come into compliance without the threat of fines or other liability. In the first year of CCPA, California's Attorney General reported that 75% of companies that received a notice to cure came into compliance within the window. The remaining 25% were either still within the cure period or were referred to further action. If compliance truly is the goal, why eliminate a provision that helps preserve AG resources and brings the vast majority of companies into compliance, targeting only the true bad actors for further justice? Finally, I know my time is short. I just wanted to highlight there are a lot of open questions on the operational side regarding the global privacy control. We really appreciate the sponsor's inclusion of the statutory guardrails when it comes to anti-competitive behavior and presupposing consumer intent. But really, those are two of the most predictable issues that we can anticipate. And I'm sure that we will be back in the future with more as those rulemaking proceedings go through in Connecticut or in Colorado and California. Understanding I want to stay within my time, I'll just say thank you again for your attention this far, and our written testimony has additional clarifying points, and I do hope to reach out if I can go into more detail on any of them.
Great. Thank you very much. Are there any questions? I guess I'll start. You know, in the interoperability, I think you had mentioned that, and I think when we talk about the sale of data with interoperability, our definition aligns with Colorado. So it does align, and I believe California. I think my concern is if we only define it as monetary, right? I think there are other ways that companies would use data. So if we said that you could only opt out of the sale of data and define it purely as sale as monetary, that would mean that you could give my data away. So I think that in my viewpoint, when a consumer wants to opt out of the sale of the data, they're saying, you know, I want your service, but I don't want you to give my information to other people. You know, whether you get money for it or something else doesn't really, you know, isn't, I think, as relevant. I think that in some ways, if we defined it as purely for money, we would be telling consumers they had a right when in essence they really didn't have a right, because you could just give it away. Does that make sense, my take on that?
Yeah, absolutely, Senator. And I do agree. I mean, it does reflect Colorado's definition, and so it is meeting that standard of interoperability. Our concern with both Colorado and this definition is just the vagueness and the leaving it open to interpretation. I think, as far as I understand, and I wasn't involved in the Colorado drafting, but you know, that concept of this other consideration was at least in part trying to target things like targeted advertising, which your bill also deals with in a separate section and holds to a higher standard. So I think that some of the consequences that you talk about when it comes to companies trying to a value other than money are dealt with later on in the bill outside of the definition of sale. So I think if there are, you know, specific issues, we like to say in our privacy principles, you know, we want to connect specific potential risks and harms to specific remedies. And so I think that targeting things like targeted advertising, like you do elsewhere in the bill, would be preferable to a definitional issue, because that really does underpin the whole thing. And if there is uncertainty in the definition, there's uncertainty elsewhere.
Okay. And the interoperability, I mean, the cure period, the cure period doesn't exist in the newest iteration of California, SIPRA. There's no, the cure sunsets in Colorado. So, you know, the amount of time, I guess, would align that we would have a cure through the same date as Colorado. So I would say, you know, I mean, I can understand why you would want it to continue, but, you know, our AG in practice has been giving companies the ability, and I get the argument on position versus person, right? What happens when things change? You do want certainty. You did mention something interesting in that California, did they require a report on how many companies use the cure period? Because you cited data from that. How was that data generated, and is that a recommendation you would make for our bill?
Yeah, so I'm not sure if that was statutorily required, but it is absolutely something we would love to see included. A report on the effectiveness of the right to cure period or the response to requests for cure.
Okay, I'm trying to think, you know, I can't think of any other questions now. And so I don't see any other hands raised. So I just say thank you very much, you know, for taking the time to come testify before us.
Thank you, Mr. Chair.
Next, Mr. Clerk, Maureen Mahoney.
Chair, can you hear me?
Yes, we can hear you.
Thank you. Chair, members of the committee, thank you for the opportunity to speak today. My name is Maureen Mahoney. I'm a senior policy analyst at Consumer Reports, and we sincerely appreciate the efforts to secure fundamental privacy rights for Connecticut consumers, especially in the absence of any federal law addressing this problem that enormous tech companies are collecting and monetizing consumer data, typically without their knowledge and consent. We appreciate all the work that has gone into this bill, not only to establish privacy protections, but also to create a meaningful stakeholder process with the goal of advancing a bill that's workable for consumers, but also to not create unworkable burdens for businesses. In contrast, states like Virginia and Utah, we've seen industry-supported privacy bills developed and move without any input from independent consumer and privacy groups. We particularly appreciate that the bill takes key steps to ensure that consumers can practically exercise their rights, including by having a requirement that companies honor browser privacy signals as a global opt-out. We've seen that opt-out frameworks just don't work. Nobody has time to opt out at 400 data brokers one by one to get them to stop selling your data. So researchers, academics, advocacy groups, many of whom were involved in the creation of the do not track signal in the past decade, worked together to create the global privacy control that once enabled sends a do not sell signal to sites with which the consumer's browser interacts. So the consumers, if they would like, can protect their privacy in a single step. I also appreciate the work to ensure that consumers have meaningful choices whether to opt out by ensuring that consumers can't be charged for exercising their fundamental privacy rights. Otherwise, those rights would be limited to those who can afford them. We strongly support the current draft of the language on non-discrimination, ensuring that, but look forward to continuing to discuss this issue with stakeholders to resolve concerns about it. Appreciate as throughout this process, the Senator is willing to do the work to find language that works for everyone. We certainly like the loyalty programs too and don't want to end them. And I very much appreciate the sunset on the right to cure and enforcement, given the relatively modest resources of the Attorney General, who's being asked to go up against huge companies with much larger staff. It's important that they don't have one hand tied behind their back with the right to cure. Of course, AG could extend a cure period at their discretion, even without a right to cure in the statute. Right to cure is not common in consumer protection laws. Was a novel provision added in California at the request of industry during the rushed month-long negotiations to create the CCPA. It will be removed in California through the second ballot initiative, with which most industry groups did not oppose. And in states like California and states like Colorado, they appropriately sunset the right to cure as well. And with respect to the California Attorney General statistics about companies coming into compliance after the cure period, that would only apply to businesses that the AG has actually taken action against and reached out to. It doesn't apply to thousands of businesses that the AG hasn't actually reached out to and doesn't have the resources to do so. I do want to flag one issue we feel strongly about. It's important to ensure that pseudonymous data, that's typically the form that data is used for ad tracking, in which data brokers buy and sell data, is covered by the opt-out, as it is in California, Colorado, even in Virginia. This is not the case in the current draft of the bill, but my understanding is it's going to be fixed, which would be essential in making sure that the bill is meaningful, especially with respect to entities like data brokers that's seeking to rein in. So thank you for your tireless work on this privacy legislation. We can look forward to continuing to work with you on the bill as it moves through the legislature. Thank you.
Great. Thank you very much, Ms. Mahoney. Are there any questions? If not, I do have a few questions. So I believe you represent Consumer Reports, so you've worked on legislation in other states around the country. So can you tell us, are there other states now that are close? How many other states have introduced legislation, I guess, like privacy legislation that you are aware of?
Well, several states have adopted legislation: California, Colorado, and Virginia, which we've talked about today. A number of states have introduced legislation as well. My understanding is over 20 states are considering privacy legislation. So increasingly states are trying to step into the gap provided by the federal government with respect to privacy protections in their reluctance to act. But what's really important about this bill is, I just really want to highlight the meaningful stakeholder process that's gone into it to, do the work to find language that helps consumers.
Thank you. Global opt-out, so it becomes mandatory in Colorado, I believe in 2025. Is that it? January, it's permissive. It has been mandatory in California. It's not statutorily mandatory in CIPRA, but they have rulemaking authority. So it appears highly likely that'll continue as mandatory, given that the head of the California Privacy Agency is an advocate for that. But can you just talk about, I think you had mentioned the technology does exist already for a global privacy signal.
Sure. So first of all, the California Attorney General, in their rulemaking to implement the CCPA, has required businesses to honor browser privacy signals as a global opt-out. So this is a current requirement in California. The AG has also specified that the global privacy control specifically, which I talked about, should be recognized as one of these signals that must be honored. So this is in effect in California, where a number of companies that also operate in Connecticut, are required to comply with. In Colorado, that requirement will kick in a couple of years pursuant to a rulemaking process. I'd also point out that in California, the requirement is added to the statute by Proposition 24, and they'll go through a rulemaking process to implement that as well. So, there is precedent for this in other states, and this is really developing on the ideas that tech activists and experts have been working on for over a decade through Do Not Track to find a way for consumers to easily exercise their privacy preferences. So many of the same people that were involved in that were involved in developing this global privacy control, which sends a do not sell signal by their browser with every business with which their site interacts. But consumers will also have the choice to, allow their data to be used and sold if there's a particular site that they want to do so.
Okay, great. And I believe one of our working group meetings, we had Professor Sebastian Zemek from Wesleyan, who had helped to develop the global privacy control. And so the first one was sent from a student in his lab at Wesleyan, the first signal that was sent. So the loyalty program language, I just wanted to talk with you a little bit about that. I believe that the language we currently have included, we had worked with you on because you had worked with, I believe it was the Hospitality Association, correct, in Washington State, which, admittedly, they have not passed their bill yet, but that language was included in there. So can you just speak about how that was worked out?
Sure. So again, I appreciate the robust dialogue about this provision. I just want to emphasize that we support loyalty programs and don't want them to go away. Bona fide loyalty programs that reward consumers for repeated patronage wouldn't be affected by this bill at all, even in the case of an opt-out, because the bill puts next to no limits on first-party use of data, the use of data by the business that you have a relationship with. What it does is that if a consumer takes an active choice to opt out of the sale of their information, it ensures that loyalty programs can't sell data to third parties pursuant to those programs, which has nothing to do with loyalty and would run counter to what consumers would reasonably expect. There's also a small exemption to facilitate the sharing of data for loyalty programs where you'd want to share your points collected at a gas station to use at a grocery store, for example. And all of this is to ensure that consumers can't be forced to choose between protecting their privacy rights and being able to afford these products. So, certainly to the extent that there are concerns that this would end loyalty programs, It's not clear to us how this would be the case, but we certainly don't want that, and are very happily engaging with stakeholders to try to address any concerns.
Okay, great. Thank you. I see Representative Cheeseman has her hand raised.
Yes, thank you, Chairman Mahoney. And I just had a question about the global privacy controls. I just did a quick Google search and it said over a dozen companies are involved in developing this. Can you tell me where we are in this? Is there actually an available plugin now that somebody can put on their website, or is this still a work in progress? Because my understanding is this is still very much a work in progress.
Sure. So this is a plugin that's available for consumers now. What's the difference between what's going on in California and what the situation is now in Connecticut? I mean, you could enable it in Connecticut, but businesses wouldn't be required to honor it as a global opt-out sale. They could do so if they wanted to, but they wouldn't be required to. So a number of privacy-focused browsers like DuckDuckGo and Brave have already implemented this, Mozilla as well. So this is increasing acceptance, but the key aspect is making sure that the businesses that receive the signal comply with the opt-out request.
So what does the business have to do? I mean, let's say, and for argument's sake, and I know simply because of our size, I wouldn't be included in this, and I'm a nonprofit, but so I have 100,000 people who are interacting with me every year. How do I set myself up to recognize this global opt-out? I'm just interested in the more technical side, and how a business would know that this is something they have to do.
That's a good question. My understanding is that it's developed in order to be seamless, to make it easy for consumers and businesses alike to be able to enable this. But for the actual, tech that goes on in the back end, I'd have to follow up with specific information, consult with Professor Zimic, who spoke before the working group.
Okay, thank you. Thank you for your testimony today. Thank you, Chairman Mahoney.
Thank you. I guess a question then for Maureen. I would assume that the majority of businesses who are collecting data, if you're a small business, it would be that it's through a third party, meaning that you're using Google Analytics or Google AdWords or AdSense. And for them, I would assume to recognize the responsibility to recognize that global opt-out signal would be through Google, which is already, I would assume, accepting that, since they're required to comply in California. Is that a safe assumption?
I don't want to speak out of turn, so I'd really need to follow up on that with the text specifics.
Okay, great. If you could follow up and get back to us, we would appreciate that. Okay. Thank you very much for your testimony. Next, Chris DeSantis.
So I don't believe Chris DeSantis has come in yet, but I'll be on the watch for him. So we can just move on to Eric George, or my bad, Nancy Libin.
Okay.
You thank you, Chairman Mahoney and Chairman D'Agostino, and distinguished members of the committee for the chance to testify today. My name is Nancy Libin. I'm a partner at the law firm of Davis Wright Tremaine, where I lead the privacy and security practice. I was previously the Chief Privacy Officer of the Department of Justice during the Obama administration, where I served on an Obama White House task force that developed a framework for consumer data privacy in the 21st century. And before that, I was counsel to then Senator Joe Biden on the Senate Judiciary Committee, where I counseled Senator Biden on these issues. And my views today are informed by that experience. I'm here today on behalf of Comcast, a company that works hard to protect consumers' privacy and has a strong track record of doing so. And we therefore commend the committee for addressing this very important issue. Businesses that operate online increasingly must comply with conflicting state laws that create an impossible compliance challenge for businesses and a confusing and frustrating experience for consumers. And for this reason, it is critical that new state privacy laws be interoperable with existing state laws. This is the only way to avoid potential legislative conflicts and enable businesses to adopt a single set of internal business processes to comply with the laws. Indeed, each new state law that differs from the others, even in seemingly minor ways, can require businesses to redesign internal programs, reconfigure databases, and renegotiate contracts with service providers. That said, SB 6 has some good features, including its reliance on much of the Colorado model, and we believe that with some modest changes, it would come closer to achieving that interoperability and aligning with current state privacy laws. To that end, we respectfully request the committee to make the following changes. Regarding the global privacy control, which was just discussed, we believe that more time is needed to allow for the development of a universally recognized global opt-out standard and to understand how such a signal would work. And for this reason, we ask the committee to amend the bill so that the requirement to recognize such signals would not become effective until January 1st, 2025. In addition, we also ask that the definition of biometric data be amended to align with other state privacy law that expressly excludes photos and video and audio recordings. This information is a critical feature in products and services designed to be accessible to people with disabilities, and the carve-out would remove ambiguity regarding the provision of such services. And finally, with respect to the definition of publicly available information, like other state privacy laws, SB 6 excludes this information from the definition of personal data, but its carve-out is narrower than those of other states. And we encourage the committee to amend this definition to ensure alignment with other state laws and to be consistent with public policy trends elsewhere. We would like to see additional changes to the bill, some of which has been addressed and will be addressed, we assume, in other testimony today. But these changes will make the bill more consistent and interoperable with existing privacy laws. Thanks very much for the chance to appear today, and I'd be happy to answer your questions.
I think Representative Cheeseman has a question, and then I'll ask some questions.
Thank you, Chairman Mahoney. Yes, and thank you. Good to see you again, Nancy. I've just 2 points. First of all, with regard to the global opt-out, and you cite the instance of a consumer, having allowed cookies on their browser, and yet there's a global opt-out signal. I presume technology is in the works that might address this, but it's still, again, very much a work in progress, as we say of legislation here.
Yes, thank you for your question, Representative Cheeseman. Yes, that's why we would like to see the date pushed out. We believe we need more time to understand how the interplay between various technologies would work. We also have concerns too that if different states adopt different signals or recognize different signals as being valid opt-out mechanisms as these develop over time, that companies would be faced with the very difficult task of trying to determine where a consumer resides, to determine whether a particular signal would reflect that consumer's, opt-out choice. So, we just think more time is needed to let this play out.
Okay, and the other related to the biometric data, and I thought it did not occur to me before, but the importance of the audio and visual components particularly for people with disabilities, I think is a huge issue, because we do not want to do anything, again, in the guise of helping other citizens that would adversely, through no intention, affect their ability to interact with the world as they deserve to do. So thank you. That was my comment and my question, and nothing further for you. It's just, as I say, good to see you again, and thank you, Chairman Mahoney.
Thank you. So let me start with, I guess, the global privacy control. And so the way the bill is drafted now, it becomes permissive, it's one of the ways to comply, and then it becomes mandatory on January 1, 2025. So when you're asking to push out the date, are you saying push out the date for it to be permissive versus mandatory? Or can you clarify on that?
Yes, we were asking for the date to be pushed out, the initial date in the bill to be shifted to 2025 when the global opt-out would be permissive. I think there's also, we believe there are a lot of issues to be resolved regarding the global opt-out. I think it's a very, appealing idea, but I think there is a misconception too that a consumer's activation of a browser-based global opt-out mechanism would opt out that consumer, and the consumer would think they're opted out across all browsers and platforms. And because it's a browser-based mechanism that is being discussed here, if the consumer logged on through another browser, the company would not know that that consumer had opted out from a different browser. And so there's just a lot more to do here. I think that it's been portrayed as a panacea, and we don't believe it is. We think there's a lot of policy issues and technical issues to resolve.
And I believe, our date is later than it becomes mandatory in Colorado, as it is. So you're just saying to, I guess, just so, again, for clarity to understand that it shouldn't be one of the options until that January 1 of 2025. And then the other is, I understand that, have different requirements for different states doesn't make sense. We also understand, given that you started working on privacy with the federal government in the Obama administration, we're well past that it's unlikely the federal government will act. But I don't know if there's any way, and I would appreciate if you could send after a suggestion of language so that you could align. Again, I think one of the previous drafts of the bill, I had wanted to put in, recognizing that this changes faster than our ability to regulate it, right? Like we're going to finally pass this law, and then new technology will be, will come along that will make some parts of it obsolete. But so what I had included previously was a mechanism that is in another state under the jurisdiction of, that the company falls, right? But if you had, suggestions for language so that it would more align the global privacy control with that's required in other states, I'm definitely open to that.
Thank you, Chairman Mahoney. We'd be happy to take a look at that and work with you on that.
Okay. The biometric data, just a question. So our definition, I believe, Virginia defines it. Colorado does not define it. I believe Colorado, it'll probably be, I'm not sure, and I will check with Senator Rodriguez in Colorado, but I would assume that would come under the Attorney General has rulemaking authority in Colorado. But it is defined in California, and our definition is not aligned necessarily to the California, but the California definition, I think, does go much further in defining the biometric data. So I guess the issue, what I'm trying to bring up here is that, with the interoperability, oftentimes we can align with one state, but it may put us out of alignment with another state. So I guess, and this isn't a question necessarily that you can answer, it's more, I guess, philosophical, is how do we decide where to align?
Well, that's a good point. I think that, and we've said this before, California is not a model to follow for all of the many reasons we've discussed before. The haste with which the initial CCPA was passed and the referendum without any meaningful debate passed subsequently. California is still trying to, repair some of the damage that they did there, and trying to clarify matters. With respect to Colorado, when Governor Polis signed the Colorado bill into law, he issued a signing statement last year acknowledging that several issues remained outstanding, and in particular expressed concern that the law did not strike the right balance between consumer protection and allowing businesses to continue to innovate, provide services. And he said that more work needed to be done in Colorado to through what he called cleanup legislation in his signing statement. And so Connecticut has a chance here to address some of those concerns and get ahead of them and lead on this area on the issues like the ones I raised earlier, like biometric data, for instance. So I think there's more to see in Colorado to try to make that law more balanced to allow the kinds of uses that I discussed.
Right, understood. And we're not necessarily trying to emulate the California model, but I guess my point in alluding to that definition is that's in existence. Companies are already complying. So as long as we don't go further, the majority, there are a lot of companies already complying with that. And understood that we don't want to hamper innovation, right? We don't want to slow down innovation, but I think in some ways, I think we need to look at the big picture, and I think in the long run, strong privacy protections can also help. They are actually good for business. And there was an article last year, Professor Sudhir from Yale School of Management, who had theorized that when people have stronger data protections, they're more likely to share their data, right, or share their data. And then that seemed to be borne out because his article came out before Apple's changes. And we saw that in Europe, where they have the GDPR, they have strong data protections, people opted in for the sharing of their data at a much higher rate than they did in the United States. So obviously, we don't want to unnecessarily burden businesses. We're trying to strike the balance, but I don't think that giving consumers data privacy necessarily means that we're not going to allow for it. And I'm not saying that you said that. I'm just more using what you said as a chance to opine on the subject.
Right. No, absolutely. We were absolutely for strong consumer protection, and to your point, I think we're on the same page with that. We just want to make sure that there aren't unintended consequences, and working with a company that has to implement this, it is very difficult to implement some of these provisions that on their face might not seem quite so problematic until you get behind the scenes and are trying to put them into practice.
Right. And, understood. It's very difficult. It's hard to visualize a lot of the things there. I'm a visual person. And so for me, I can't necessarily visualize data flowing, and what it makes it hard sometimes to understand exactly what these different pieces do. You mentioned the difference in publicly available information. I know in some ways we've received criticism for some of the exemptions. So I guess I'd like to, and we did try to align. So, I am open to what we need to do with, if you could just describe a little bit better what needs to be done with the publicly available information.
Sure. We would like to see that exemption expanded to allow, or to include, I should say, let me put it this way. We'd like to see that exemption expanded so that the definition of personal data excludes information made available by a person to whom the consumer has disclosed the information, so long as the consumer didn't restrict it to a specific audience. So there may be circumstances where a consumer has disclosed personal information, but restricted that to a certain segment of people, and we want to respect that. But when a consumer has disclosed personal information and sort of, put it into the data stream of commerce, so to speak, we would like that to be exempt from the definition of personal data as well. And under the current definition, it is not exempt.
Okay, so, and I need to reread because there have been a few iterations of the bill, and I know in one we did have it the way you were describing it, right? That information made available through social media channels that was not restricted. So if I didn't put it out and say this is only for my friends, if I said it was only for my friends, it's not publicly available. If I did not restrict it to only my friends, then it was publicly available. Is that?
That's correct.
Yeah, okay. Yeah, and so I need to review because I know that there have been so many iterations of this bill over the past couple of years. So, so understood. Your contention is that if people put it out there, it is obviously www, World Wide Web. And so if you're putting it out worldwide and don't limit it specifically, then it is publicly available. Okay. So if you wouldn't mind just flagging me with that and emailing that back. I know I have your testimony, but specifically, I would appreciate that.
Sure.
And I think Representative Cheeseman has an additional question.
Thank you very much. Apologies, Chairman Mahoney. Nancy, so would the global opt-out work with apps, which are now ubiquitous, both on our phones and, iPads and laptops? How can you comment on that, please?
Sure. I think this is one of the issues. Today, I am aware that there is work has been done on a signal that is designed to operate on a browser, on a website browser. I'm not aware of anything similar available on apps. And I think that's one of the issues that you raised. One of the complicating factors about this is that we just don't know enough yet about how that would work, or if that would work on apps, so that if somebody went to a company's website and then went to an app on their phone, would that opt out with that particular company even carry over to the app?
Right. And I think the Restaurant Association touched on this because, with the, Open Table for restaurants, Grubhub, the delivery services, DoorDash, all of those are apps. Yet if the restaurant or somebody else, delivery services, for heaven's sake, we're now being allowed to have marijuana delivered to our houses. There's going to be a marijuana app before we know it. Where does that play in? Because obviously they're still processing consumer data. Okay, I'm just curious as to how that. Okay, thank you very much for the answer. Thank you, Chairman Mahoney.
Thank you. Are there any further questions? If not, thank you very much for your testimony, but more importantly, thank you for all your assistance over the last couple of years. I know we've spoken many times over the years, and I always appreciate the insight and the experience you bring. So thank you.
Part of it. Thank you.
Mr. Clerk, next up is Eric George.
Thank you, Chairman Mahoney, Chairman D'Agostino, members of the committee. I am Eric George. I'm the president of the Insurance Association of Connecticut. The IAC is a state-based trade association. We represent Connecticut's P&C and life insurance industries. And the insurance industry is a critical component to the Connecticut economy. We serve as the oil for our economic engine. First, we are the first to respond to individuals and businesses' financial crises. Second, we invest heavily in other economic sectors which allow them to grow. And finally, we allow commerce to work by limiting the risk of loss so that businesses operate in the commercial context. I'm going to be a bit of a cheerleader here, but if in my testimony, I refer to the 2020 Connecticut Insurance Market Brief, I encourage you to look at the facts and figures here. But briefly, we lead the nation. We've been in operation in Connecticut for approximately 225 years. We lead the nation in insurance employment, in insurance payroll, and insurance gross state product, as well as direct written premiums. We're third in the nation in terms of the overall number of domestic insurance companies and non-domestic insurance companies licensed. So we really are a hugely beneficial segment of the Connecticut economy. And that is my segue into our strong belief that privacy protections for consumers must exist. Privacy requirements that are consistent and equivalent across state borders would be the most ideal situation. But we understand that there is a desire for states like Connecticut to act in the privacy arena. And I also want to take a moment here to strongly give credit to Senator Mahoney. Others have said it before, but he really has brought together all different stakeholders to foster a true collaboration and deliberation on this extremely difficult area. So if we're in a position where the Connecticut General Assembly is going to act in this privacy arena, we strongly encourage, recommend, ask this committee that current state and federal regulatory frameworks for safeguarding consumers' personal information is harmonized with Senate Bill 6. And we request that clear and unambiguous language be included in the bill, specifically in Section 3, to establish that the existing legislative and regulatory framework be adhered to. Specifically, Senate Bill 6 does need to contain a clear entity level federal Graham-Leach-Bliley exemption. And it is our understanding that this bill will be amended to include such a entity level exemption as it progresses. Before I close, I just want to again thank Senator Mahoney. This has been an issue that we've all been facing for years, and the senator has been an absolute leader. I think that when a product ultimately lands in a space where not everyone is fully happy with it, it's probably the best thing that you can have, because really it means that there was compromise, there was deliberation, and there was collaboration. I'm going to stop there with my prepared remarks and answer any questions that you might have.
Great, thank you very much, Mr. George. Well, Senator Kissel has his hand raised, so allow Senator Kissel.
Great.
Senator Kissel, if you could unmute yourself, please.
Trying to be good by muting myself. Sure, I'm sure my Senate colleagues would like to mute me quite often. First of all, Mr. George, Eric, great to see you. And my best to your wife, and hopefully your family's doing fabulous as well. I agree with you. I'd like to be associated with your remarks regarding Chairman Mahoney. I know he's worked just really, really hard on this, and oh man, it's like a bowl full of fish hooks that you pull out one and it's like connected to a million other ones. Not easy, but a laudable goal. This Graham bill, Graham-Leach-Bliley, the folks from the Attorney General's office mentioned that early on. And I'm just wondering why that's of concern to the insurance industry. And by the way, I knew that once in the day we were, the insurance capital of the world. And then I thought like, oh, we were like losing out to like South Carolina or South Dakota. And it's nice to know that the figures are still robust in Connecticut. That's very reassuring. But Eric, why this federal law? How does that impact you guys?
Certainly, there's a lot there, so let me take it in turn. The Federal Graham-Leach-Bliley Act is a law that concerns financial institutions and how they deal with consumers and private information, consumers' data and private information. And why it's so important is that the insurance industry is one of the most heavily regulated industries in the world. So we have current standards, metrics, obligations that we have to adhere to that are spelled out in Graham-Leach-Bliley, I'm not going to be able to tell you that I'm an absolute expert, but I know it enough that guide how we deal with consumers' information. Moreover, on that, we are regulated by our Department of Insurance here in Connecticut. I encourage any member of the committee to talk to the department and ask them how we are regulated in terms of data privacy. We have, as the state of Connecticut, our own consumer data privacy law for insurance companies alone, dealing with cybersecurity. And it deals with how, if we have a breach, how we are to go about notifying the department. The department is absolutely overseeing everything that we do. So what our concern is as you layer additional rules and regulations, melding those and synthesizing those for an already heavily regulated industry gets extremely problematic, if near impossible. So we're not like many other industries where they are not as regulated as we are. And I actually want to take a moment to add some more to something that you said. We are still the insurance capital of the world. No matter what other people say, the state of Connecticut is still the insurance capital of the world. And I've had this conversation with Senator Mahoney and others. It is so important as the nation goes and individually, all of the individual states looks at how they want to deal with data privacy. Because of Connecticut's importance as an insurance industry leader, we really, the eyes on us from an insurance perspective are much keener than they are onto other states where it might be an industry, but it's a much lower level industry. So where goes Connecticut really has an impact for the rest of the insurance industry throughout the entire nation.
No pressure, Chairman Mahoney, regarding that. But that's really, not to sound jingoist about our insurance industry, but I love it. I'm glad that we're still number one. And clearly, similar to one of the other legs of our stool, military production, electric boats, Sikorsky, so many others, Hamilton Sunstrand up here. Well, now they've changed. I forgot their new name, but we just have so much going on there. Arsenal of democracy throughout the world. So I know we don't want to kill or throw out the baby with the bathwater, or kill the goose that lays the golden egg. But clearly our goals are laudable. So I very much appreciate your elucidation regarding that federal law and the fact that your industry is so heavily regulated already, not to make it difficult proposal that much more difficult, but clearly a lot of moving parts. Thank you very much, Mr. Chairman.
Thank you, Senator Kissel. All right, Mr. George, I have a question. Do all insurance companies fall under GLBA, or is it only property and casualty?
No, we're considered financial institutions, so all insurance companies would fall under GLBA.
Okay, so health insurers would.
Yeah, I mean, I know that they have competing or other interests as well, but and I would encourage you to talk to them, but I can't see why they would not be considered financial institutions.
Okay, well,
I would defer to them.
Okay, and I would assume that they're collecting HIPAA covered data and other federal regulations, but I just was wondering if the GLBA applied to them, and I will check with them as well. So, okay, I don't have any other questions. Thank you for your time. Thank you for your participation in the process, and I look forward to continuing to work with you on this proposal as it moves forward.
Thank you, Senator Mahoney. Have a great day.
Thank you. You as well. Okay, Mr. Clerk, next, Ryan Harkins.
Thank you, Mr. Chairman and members of the committee. My name is Ryan Harkins. I am Senior Director of Public Policy with Microsoft, and I'd like to thank you for the opportunity to testify today. We support SB 6. Microsoft has been calling for comprehensive privacy legislation in this country since 2005. We think it is incredibly important to earn back much of the trust that we have seen the public lose in technology by addressing concerns about privacy and passing new and robust laws that would provide consumers with robust protections while ensuring that businesses can responsibly innovate. We think SB6 is a very thoughtful and responsible approach. It would provide consumers with the rights that they need in order to control their personal data. That includes the rights of access, correction, deletion, portability. It importantly includes the right to opt out of the processing of personal data for purposes of targeted advertising, data sales, or consequential profiling. I have to say that we support the current definition of sale and think it's appropriate to cover exchanges for monetary consideration or other valuable consideration to ensure that you are covering data for data exchanges on the internet. We would also support the modification that Ms. Mahoney suggested to ensure that the opt-out right would apply to pseudonymous data. We also support the imposition of affirmative obligations on companies to be responsible stewards of the information that they collect. This includes the obligations to conduct data protection assessments of their processing activities, as well as the obligations to be transparent, obligations of data minimization, and obligations to secure the information you collect, among other things. So we think SB6 would be a great step forward. It would build upon the European Union's General Data Protection Regulation, or GDPR. It would build upon the laws that have already passed in the United States, in California, Virginia, and Colorado, and we would encourage you to pass it. So thank you again, Mr. Chairman, and I'd be happy to try to answer any questions you may have.
Great. Thank you very much. I don't see any hands raised, so I guess I'll just ask a few questions. I think one of the things I've noticed from your suggestions in speaking, well, first off, thank you to you, but to Jay Somerson as well for your input. And I also, in speaking with senators and representatives from other states, I know you've been very helpful in other states as well. So thank you for that work and for your input. It's very valued. It looks to me like a lot of your recommendations could be construed as making this bill stronger rather than weaker. Is that, in some ways, it sounds like you would prefer, I don't want to put words in your mouth, say prefer, but that you believe there are opportunities to strengthen this bill. Is that a safe characterization?
Yes, Senator, that is fair to say. I mean, look, as with any complex and big piece of legislation, there will always be things that you could say tweak here or there to strengthen things further. We certainly think that there are opportunities in the current bill to do that. An example would be to expand the deletion right. It currently would apply to data collected from or about a consumer, which is great because it means it would apply to data that is not only obtained from a consumer, but data that a company, say, purchases from a data broker. A modification that you could make would be to make it apply to personal data concerning a consumer. And that would ensure, consistent with Colorado's law, and frankly, consistent with GDPR and the international standard, that it would also apply to personal data that a company infers or derives from existing sources of data. But as I mentioned, we think the bill is a great step forward and we do support it.
Great. And so an example, I guess, data inferred, my cat was about to step on the power button on my computer, so I had to play a little defense for a second. Data inferred about a consumer, I would assume, I have an example from a colleague. He drinks a CBD tea at night. His girlfriend has never searched for that tea, never purchased that tea, yet she now sees ads for that tea. So is that an example of how something could be inferred because of perhaps the geolocation of the phones were frequently in the same area, that or, I don't know how, I can't pretend to think how the algorithms work, but would that be an example of something that may be inferred about a consumer?
It is, and even more basically, if you step back for a moment, when, for example, targeted advertising profiles are created about each and every one of us, those profiles are based upon your web browsing activity. So your activity as you traverse the internet across different websites. Well, typically those profiles won't contain the raw web browsing data itself. They will contain inferences that have been derived from that activity. And so if you want to ensure that the deletion right applies to those inferences, say, this is Ryan Harkins, he's in his mid-40s, lives in Seattle, is married, and likes the Seahawks or something else, then you would make the tweak to the deletion right that I mentioned.
Now, you mentioned GDPR, so that I guess it already applies to inferred data in Colorado, GDPR. What are some of the other differences? Is GDPR an opt-in model versus opt-out for? No, okay.
It is not. Yeah, GDPR, it's a common misperception that we see in the United States, but GDPR is not an opt-in consent model for, say, all data collection and use. The GDPR requires companies to establish a lawful basis before they can collect and use and share personal data. There are 6 lawful bases that GDPR spells out, one of which is consent, but another is something called legitimate interests, which involves a balancing test, and you have to weigh your interest as a company in collecting and using the data, the interests of the consumer and their rights, etc. So there's a lot of data collection that is entirely permissible under GDPR without requiring consent. Now, GDPR does require consent in some circumstances, like, for example, it requires opt-in consent in order to process sensitive data consistent with SB 6, which we think is an appropriate standard.
Okay. Great. Thank you very much. I don't know if I see any further questions, but thank you for testifying, and thanks to you and to Mr. Summerson for your assistance with the bill.
Thank you, Mr. Chairman.
Okay, next, Tim Phelan from the Connecticut Retail Merchants.
Morning, good morning or good afternoon, Senator Mahoney and other members of the General Law Committee. My name is Tim Phelan. I'm the president of the Connecticut Retail Merchants Association. I want to thank you for the opportunity to provide testimony today on Senate Bill 6. We already submitted my written testimony, and I do have some comments that may take some time, so I'm going to jump right into them if that's okay. First of all, let me just echo those other comments made by others about the work of Senator Mahoney in trying to put together this comprehensive bill. It's not been easy, and we appreciate all his efforts and also the ability to work with him. We believe the draft bill you've developed is foundationally strong and reflects that hard work that Senator Mahoney has done. However, there in one critical area, more work remains to be done, specifically as it relates to loyalty cards. We're concerned the bill as drafted misses the mark because it could jeopardize the broad range of bona fide customer loyalty programs that Connecticut consumers choose to participate in. We're confident that this can be corrected by the committee, and we pledge our continued effort to work with the committee leadership and with other stakeholders to reach an agreement. As of now, however, we cannot support the current language because it could result in a reduction in the number and variety of customer loyalty programs offered to Connecticut consumers. We don't believe this is a good public policy, and it's not what consumers expect from our industry. I want to just take a couple of minutes and explain why. The current draft bill includes novel language in the section dealing with bona fide customer loyalty programs that does not align with data privacy laws already enacted in other states. This is a big deal to us. It would force Connecticut to stand out, and not in a good way. Retail customers love loyalty programs, and retailers are happy to offer them. It is a great way for us to build relationships with customers in an important part of our business. According to a recent Forrester study, nearly 80% of consumers participated in at least one loyalty program, and the average adult participates in more than 9. Yet the language in the bill creates significant ambiguities that could negatively impact consumers as well as retailers who operate those programs that are designed to benefit them. We believe Connecticut consumers have the capacity, just like the consumers in other states, to make intelligent and informed decisions to choose voluntarily to opt into a loyalty program offered by a trusted company, a company that they have an existing relationship with, to receive the benefit the company offers and that the consumer wants. That's how retail loyalty programs operate. And we believe Connecticut consumers rightly expect the public policy of our state to preserve their right to choose the benefits offered in customer loyalty programs that they voluntarily join, rather than adopt the novel theory that could jeopardize the continued availability of a wide variety of plans in Connecticut, even as they continue to operate as usual in nearby states. Doing so could quickly create a disparity that would make a difference, hurting Connecticut retailers, Connecticut consumers, and ultimately our Connecticut economy. As I mentioned, I hope this aspect of the bill can and will be revisited and corrected. I also wanted to make 2 other points. First, the July 1.
Mr. Fallon, just a heads
Okay.
up, you're past your 3 minutes.
Senator Mahoney, if I could just indulge you for 2 more minutes to make these 2 other points. I think they're important for our industry, and I think the committee would benefit.
How about this? I'll ask you the question. Mr. Phelan, what are your 2 other points?
Well, thank you, Senator Mahoney. That's a great question. First, we are pleased to see that the effective date in the bill was changed from a July start date to a January start date. That would, for obvious reasons in the retail industry, make our life a lot easier. However, we would urge the committee to adopt the July 1st effective date, which is at least 2 years after the date of enactment, rather than the 1 year that's specified in the bill. The 2-year standard for making the new law effective and enforceable after an enactment is consistent with implementation periods covered in bills that have already passed in the states of Virginia and Colorado. And we strongly encourage the committee to afford Connecticut businesses the same 2-year timeframe for implementation that is afforded to those businesses in those states. And the reason we ask for this is because this is the first bill of its kind in the state of Connecticut, and its application will cover nearly all consumer-facing businesses of all sizes. That will be considerable. Therefore, there will be a considerable learning period for the regulated community, regulators, consumers alike, to fine-tune their experiences and responsibilities under the law. And it will take businesses, especially retailers, time to develop effective and efficient processes to promote compliance with the law. This is true because most retail establishments have less than 50 employees in a single location. They lack the in-house legal counsel and operate on very thin margins for compliance purposes. This constrains their budgets and limits their ability, as I mentioned, to hire outside legal counsel that would be required to develop necessary methods to comply. The effective date should be set far enough out in advance to allow these companies to achieve compliance, which is the overall goal of the bill. And one last point, Mr. Chairman, the small business protection. There has been previous discussion about the lowering of the threshold from 100,000 consumers to 65,000 consumers. This also is a big deal. With all due respect, Senator Mahoney, you and I have bounced this issue back and forth. The 65,000 customers called for in the draft, we think, would sweep in many more retailers than initially thought, especially with the addition of the global opting out. And we know from experience in California that the cost of compliance for small businesses is significant. So we would ask, and I could get into more detail about that cost, but in my testimony, we have some data from California, but we would just ask that the committee consider again moving the threshold back up to 100,000 as was in previous drafts. I would just close by saying again, like I said in the beginning, we appreciate the effort that you have put in, Senator Mahoney, to this bill and other members of the committee. This is a big deal for Connecticut retailers. We are a consumer-facing business. Our relationship with customers is the most important part of our business. We don't sell our data. We want to work with the customers. We want to continue to offer loyalty cards because they're so popular with our customers. So we have a great stake in this bill, and we want to continue to work with you throughout the rest of this process. Thank you. I'd be happy to try to answer any questions you might have. And thank you, Mr. Chairman, for your indulgence.
Are there any questions? So I guess, how many of your members have businesses? How many of your members are national that would have locations in Virginia, Colorado, and California?
Well, I mean, it's hard to put an exact number on that. I mean, our membership is pretty diverse. We have some of the world's largest retailers that are members, and I'm certain that they have stores in those two states as well as California.
Okay. And, again, thanks for your input through the process. We did add in, the intent wasn't to draw on the small convenience stores. We made it very clear in this bill that if you're only processing data for the purpose of a payment, that doesn't count towards that number.
Yeah, Senator Mahoney, I would say, in the interest of time, I couldn't make that mention, but we do very much appreciate you exempting out credit card transactions.
Right, and then we had moved it, an earlier draft out of January 1, which you had pointed out was, inconvenient, but it also, I had meant to align it with Colorado, so we did move the date there.
And we appreciate that, Senator Mahoney, very much. Thank you.
And again, we have talked about much on this issue, and so I know, one of the businesses, the intent is not to punish small businesses. The intent is to protect consumers without, unnecessarily burdening businesses. I will say I didn't see your testimony last night, so I'm not sure what data you mentioned from California, if that was estimates or if that was actual cost of compliance data.
Well, Senator, I would, why don't we, I'll follow up with you in more detail on that, but we think that it is more accurate data. It's data that was derived from a survey that was done, and we think it more accurately reflects the actual cost that businesses will have to, that they're incurring to comply. And I'd be happy to go through this with you offline, as the costs obviously increase depending upon the size of the business. So it's hard to kind of give it a blanket example of an overall cost, but it is significant.
Okay, and then with the loyalty cards, we definitely want to work on that language. We don't want to, I definitely use my loyalty programs to get my free cup of coffee after my 80 gallons of gas. So
I just want to say, I want to add, Senator Mahoney, we certainly want to continue the dialogue. I guess I wanted to make pretty clear to you and the committee that, the relationship that the retailer has with customers via their loyalty card is one that's built over time, and there is a trust there. There's no suggestion or some sort of implied kind of hoodwinking that may be taking place in terms of gathering data via a loyalty card. The loyalty card is a simple expression on the part of the consumer and the retailer that, hey, you're a good customer. How about, you keep coming back and we'll give you these benefits. And there's ways that, we do this so that customers trust us. And we think the greatest protection that affords a consumer in that response is that they're voluntarily opting in to take advantage of the loyalty program. So I just want to take a second and sort of reemphasize that, if I could.
Yeah, and just I guess so I can explain for people who may be listening, may not understand, why do we need to put in an exemption for loyalty, since everyone seems to like a loyalty program, and that the bill creates, it prohibits pricing discrimination. So it prohibits people from charging more if someone opts out of the sale of their data. We don't want people to be punished for exercising their rights. However, some may view that if you've opted into a loyalty program, that then that is a different price. So we just want to make it clear that if it's a bona fide, if it's a real loyalty program, no, that isn't a different price. You're getting a value. It's a trade for your loyalty. And I guess that where we need to get clarity in the language is just understanding whether or not, if you had said, well, I want to be part of your loyalty program, but I don't want you to sell my data, which I would say, I don't know the percentage, right? I would assume the vast majority of loyalty programs are not selling their customers' data to someone else. They're using it to make sure that they're getting more of the products that they like within the store. But and that's, I guess, the issue is, should one supersede the other? And I get that the loyalty program is an opt-in, so does that supersede if someone then had opted out? And is that the exchange then for allowing a company, even though, as you've said, most of them don't sell the data, but allowing them to do so? And that's the issue, is just arriving at language that satisfies both concerns. And right now, and I understand because it's not in other states, and it hasn't been interpreted by the court, like our contention is that, not contention, because, we're just trying the language and trying to find what works. But I believe that the goal is the same. It's just ensuring that we get the language to get there to both of our stated goals.
Okay, and I appreciate that, Senator, and we'll, as I said, we'll continue to work with you on that issue. I do think it's important for our industry, just like it is for all other industries that are impacted by this bill, that, we have consistency among states, and that, we have national retailers that operate in Connecticut that also operate in those other states. We don't want Connecticut to stand out because somehow we've got a different type of program, that interoperability that's talked about a lot. I think we could get to the goal that you're talking about, but I would hate to do it at the risk of putting Connecticut businesses standing out as somehow, we do it differently than everybody else, when with respect to loyalty cards, we feel like there's already enough protection built in with a voluntary opt-in.
Right. The converse is that since you do have businesses that are operating in other states, in operating in the states that their citizens have these rights, so why shouldn't our citizens also be entitled to these rights? If your businesses, some of your members are willing or required to give them to other people, why not give those same rights to Connecticut residents, would be the converse of that argument. And so, are there any further questions? Oh, okay, hearing none. Thank you very much.
Okay,
and thank you for your work through the process. Okay, next, Andrew Kingman.
Hi, good afternoon, everybody. Can folks hear me okay?
Yeah.
Okay, great. Thanks, Chairman Mahoney, Chairman D'Agostino, members of the committee. My name is Andy Kingman. I represent the State Privacy and Security Coalition. I also work on the compliance side of privacy laws, helping companies work through compliance issues in all the various different states here. So I wanted to first echo what many of the other folks have said before here, and applaud and thank Senator Mahoney for his work on this bill, and being willing to listen to lots of different viewpoints and try to incorporate them to the extent possible in the bill here. We have a few issues. Our testimony sets out I think 5 different issues. I'll just touch on 3 of them today. Enforcement, the provisions around COPPA and proprietary information, In regards to enforcement, hearing the AG's testimony earlier today and understanding some of the discussion around this, I think we're still would still love to work with the senator on ways to separate out good actors from bad actors. We think there's maybe some more work to be done here. We do believe that most businesses are trying to comply and trying to be good actors. And I would also note that, not all violations here are intentional or necessarily ones that would injure consumers in a material way. To the AG's point about this being, their common practice, kind of taking a lot of the different factors into account. I can speak from experience that their office is often very receptive to that. We've worked through several different incidents. However, we believe that those should be codified and various personnel change, attorneys general change, and I think having that certainty of that in the law would be very helpful. The California Attorney General's office has been central here. They've actually built their own tool for consumers to send notices through the AG's office. So this is an issue we're considering continuing to work on and appreciate this committee's consideration of those. Would like to see the children's privacy piece here align with federal law and with Colorado. This would involve primarily changing the definition to recognize that much of the FTC, much of the work on COPPA is going on at the rulemaking level as well. And also aligning the provisions around consent with COPPA and with Colorado here. And then the last piece on proprietary information, we would appreciate consideration for companies we would appreciate appreciation for provisions that would allow companies to avoid disclosing their proprietary information. So this would include a change in the right to portability that would allow customers to port to other companies only that material which they provided to the controller. And then an exemption for trade secrets so that they are not required subject to an access request, to a portability request, et cetera, that they not be required to provide trade secret information back to consumers. So I can see my time is up. I'm more than happy to answer any questions, and thank you very much for your consideration.
Great. I see Representative Cheeseman has a question, and then I have a few.
Thank you. Thank you very much for coming in here today, Mr. Kingman. So in terms of, we've heard a lot about the, California and costs that were vastly overblown or underestimated. Can you tell me what your experience has been in terms of the costs, not only monetary ones, but time, which of course is money for businesses dedicated to complying with the terms of the California law? Yeah,
sure. So I think there are a few pieces there that have been difficult for businesses. And, we've talked a little bit, I know there's been a lot of discussion about the scoping of small businesses here, but the California AG's own study suggested that in that state, for initial startup compliance costs for businesses with fewer than 20 employees, the estimated cost was $50,000 in compliance costs. And for businesses with fewer than 50 employees, that cost raised to about $100,000. And I think that that's actually a fairly accurate representation of what compliance costs look like. Obviously there are advantages built into complying, with laws for larger companies that have the scale there. But a lot of the things that bring up compliance costs that everybody would have to go through. The first is drafting privacy policies that are specific to the requirements in a particular law. Again, this is where interoperability really does come into play, because the more commonalities across states, the better. But in places here, I just mentioned the consent mechanism for children, where there are particular differences that require particular architectures for technically on the back end to identify those individuals here. If we're talking about children up to 18, that's a different population to identify in Connecticut than it would be anywhere else. Things along those lines. And then also for Connecticut businesses, the other major cost that we see is renegotiating contracts with vendors. Understanding that payment card transactions are not included here. I still think there probably would need to be changes in the contract between controllers and processors to reflect the contractual requirements in this bill and ensure that they're all compliant here. And so those are some of the real large costs that add up fairly quickly. The other things would be, bringing on vendors to help comply with this, like vendors that work on opting out, opt-out solutions for consumers and for businesses. So those are the types of costs that, again, add up fairly quickly. And, we appreciate the thought around trying to, balance small and large business needs here, but those are compliance costs that are pretty typical across the board that we see.
Okay, thank you very much for your answers. Thank you, Chairman Mahoney.
Okay, thank you. All right, Mr. Kingman, given the fact that that was a 2018 estimate before the bill went into effect, do you have any actual data? It seems like that's used as more, but again, when that was went into place, people didn't have experience, right? You see that, economies of scale, once you've done things,
Sure.
it becomes easier to do. There's architecture that's been developed because of California. But again, a lot of times when we estimate things, especially when it's uncertain,
Sure.
we overestimate. So
yeah, no, and I apologize for not making clear. What I was trying to get at is that's also been my experience working on projects with companies who are implementing that law, that there are all of these different costs. I think, every business has a different business model. And so trying to really dig in, sometimes those economies of scale are great for the large pieces, but for, honestly, as this hearing has been going back and forth with a colleague about a very large company that is trying to determine, whether they meet the definition of sharing under California, under the CPRA, which is coming into effect as well. So, these are the types of questions that are ongoing. I would just say, in my experience, I think that's a fairly typical cost. And I would say for larger businesses, it goes well beyond that. But, recognizing that there are some economies of scale, wanted to focus more on the maybe more the medium-sized businesses here.
thank you. I spoke with, my brother-in-law owns a franchise, so the franchise would take care of, he's out in California, so he doesn't
Sure.
have to deal with the website. But I asked him to put me in touch with, if he had any friends who owned restaurants. Again, I'm trying my best to make sure we're avoiding the unintended consequences.
Sure.
And
Absolutely.
so I was able to communicate with, and I'm not going to, because I didn't ask permission to disclose the name, but a restaurant group. They own 25 restaurants in California, and his comment was initially it was $10,000 to $15,000. He doesn't remember because it was several years ago, to get the privacy policy set up in 10 hours, laying everything out, and then he's been compliant and hasn't seen any issues. He did like the fact that it, California does not include a private right of action, nor do we. So I think that those estimates are well, again, I have that's a sample size, an N of 1. But I think that you see, when I had to partner with the business in California that asked me to put the privacy policy on, and she referred me to some different websites where you can go. Again, tools have been developed now for the do-it-yourselfers. 43% of web traffic goes through WordPress. There are plugins that you can purchase to bring yourself in compliance, as well as, I've spoken with a lawyer who had said if he was to do the privacy policy to bring people in compliance would be $3,000. So I think, I'm not saying it's free, but I'm saying that the costs I think may be overstated in that estimate.
Yeah, I've probably done 10 to 15 projects for clients, and again, that's been my experience. So I can only share my experience. I think, I would not advise companies to just buy a plugin and try to be compliant with CCPA, because there are so many different moving parts there. But
well, and it also differs on whether or not you're collecting data, right? Like if you're a website that is your main tracking is through, Google Analytics or others, obviously the tools have been developed by Google that you just have to have the link there that people can opt out of the sale or targeted advertising. You did mention, I guess in terms of the enforcement, and in a conversation offline, you would say you were trying to give some options, which I guess one of them, which I do kind of agree with, is perhaps allowing a cure period for privacy policy violations, but not, others, because it again, in my view, privacy policy is easier to bring into compliance if you sell someone's data. If someone is it's important. This is an opt-out model, so people have taken the time to find out how to opt out of the sale of their data, and you still sell their data. It's harder to figure out how you, for me at least, to figure out how you can cure that. But I do agree, like privacy policy, there are other footfalls, right? Little things that that you can bring into compliance. So is that, would you have suggestions about?
Yeah, I think there are a
bifurcating?
couple of different things that, and again, we'll be sending over some language, in the next day or two here. But a couple thoughts. The first, we do agree with I think TechNet, who suggested that the Attorney General report out on their experience with the right to cure. But I think also just some evaluative criteria before bringing an action. I think from an enforcement perspective, again, of course, we appreciate the lack of a private right of action here and think that that's a large step towards making this workable. I think the current language in the bill is a per se unfair and deceptive violation or finding for any violation of this act, regardless of how material or immaterial it may be, or how intentional or unintentional. And so I think adding some evaluative criteria to that the Attorney General's office could take into account, whether that be a history of violations, whether it's caused by technical or human error, things along that nature, that could just allow perhaps some additional scoping of the problem, and maybe the likelihood of whether the controller processor can mitigate or remedy the violation, things along that nature. So would love to continue working on that. That wouldn't necessarily be limiting the right to cure or expanding the right to cure. We think that it just allows both businesses and the AG's office to, again, focus on compliance and not necessarily punishment. And I would also point out that the Attorney General's office has the full, weight of the state's UDAP statute, which is a very strong UDAP statute, outside of, any of the confines of this bill, and could still bring actions for, very unfair and deceptive violations of the act, or, a clear bad actor, that would be, still available as a remedy to their office. So I think there's some opportunities to continue to provide some assurances and still meet the Attorney General's and your goals, Senator.
Okay, thank you. The proprietary information, can you just elaborate on that a little bit? I understand in the portability, but what is the other exemption? Like, I guess to trade secrets, like how would, is it, because I know we did take care in the, the release, the Attorney General can request the data protection assessments, and we try to make sure that that information was protected. So is that the section, or is there another section I'm missing where we're providing?
No, I think we'll likely, again, in the language that we'll be sending over, I went through the piece in the data protection impact assessment, protects attorney-client privilege and basically is dealing with the interaction between the Attorney General's office and the controller. And what there actually isn't any language for, and I did look through fairly carefully to see if I could find a way to find that protection. But when you're dealing with an access request, when you're dealing with a portability request, you're returning data to the individual. What we want to avoid in the portability scenario is divulging information that a business knows the consumer is going to give to another business, and divulging information that would put them at a competitive disadvantage. And then with the trade secrets, just having the sort of basic protection to say, if we have particular intellectual property that's not really appropriate to be shared with the public, that's very, kept very closely under guard, that we want to be able to protect that type of information as well.
Okay, so yeah, I'll have to look at your language because, we don't want to require someone to divulge their trade secrets or proprietary information, but I'm just trying to understand how this puts that at risk. That's all. I'm not saying it doesn't. I just myself, I'm having a trouble visualizing.
Sure, it could be information around how a company might make recommendations to an individual, something along those lines, or how a company might communicate, the different methods that a company might communicate with an individual, or something, that would be particularized, that would allow other companies to go, oh, okay, well, they're doing it better. How maybe to prioritize content, things along those lines. So that's the type of activity that, is generally considered very proprietary, that we wouldn't want to allow, but that I don't think presents a real question around, consumer privacy or the way that it would interface with these rights. I don't think it would weaken the statute at all. I think, there are trade secret protections in various laws and in a different context here.
Okay, no, understood.
Yeah,
so
yeah.
I'll look for that language and like to work with you on that.
And again, we appreciate your consideration.
The children's privacy piece, what is, and I have Colorado statute here. I reviewed it last night. I just don't remember exactly. So Colorado does not go beyond COPPA?
No, they require opt-in consent for the parental opt-in consent for using sensitive data for a known child, but also allows COPPA compliance. If a company is complying with COPPA, that suffices for compliance with Colorado.
Okay, and I believe we have, and I need to double check. I do believe we say that if you're complying with COPPA, you are determined in compliance. I'll have to review that. If we're missing that, that is, again, and I believe, where we differ is that we extend those COPPAs only up to age 13, and California goes up to those same things to require opt-in consent for targeted advertising up to age 16, and then our bill, I think there are two areas that we're the only ones in the country to do something. One is to require an active email address as a privacy policy, but then the other would be to bring those protections up to age 18, which, given the president's talking, statements at the State of the Union on the importance of children's privacy, given the fact that several of the caucuses have been talking about the, concerned about the potential harmful impacts of social media on children. I guess, again, we're trying to stay with interoperability, right? But we're also looking at, ultimately protecting the consumers in the state of Connecticut. So,
Sure. Yeah, and I think one of our recommendations is that excuse me. One of our recommendations is that the definition of COPPA be amended to recognize that much of the work at the federal level is being done, in the regulatory space through guidance and rules, rather than, at the legislative level. I think, for us, the willful disregard language is not found in, Colorado or the other states that sort of follow the Colorado model. And I think, would love to see that synced up as much as possible there.
So the actual knowledge, though, that is, and
and that's that. I mean, the actual knowledge is a COPPA standard again. So, that's kind of where we feel like that's the right place to land. What we don't want to do, what we don't want to see is, websites that are targeted to, just a general audience start, making all of us do age gating just to access a website, right? I don't think that's a great outcome, and I'm not suggesting that that's the definitive outcome, but businesses will, if we're starting to talk about young adults up to 17 years old, businesses are going to have to start figuring out ways to identify that group in Connecticut only much more carefully, and that would be the most obvious way to do that. I'm not sure that that's the most efficient way to sort of work on children's protection. So anyway, we'll send over some language, and again, would welcome your thoughts and continued work there.
Well, no, thank you. Earlier the AG testified that that there is movement towards constructive knowledge rather than actual knowledge. That actual knowledge was a high bar, and I'm just wondering, how is that? Since you have done a lot of work with other states, how is it in practice actual knowledge currently in California, where it goes up to where it does differ from COPPA, right? So it goes up through age 16. So how do they determine the actual knowledge?
I think every website, every company probably does it differently. What I can do is come back with maybe a couple of examples on how that is playing out there. But again, I think age gating, when you sign up for a service is probably the most common, but I think it very much depends on the type of business, the type of product that you're offering, your general conception of who the users you want to be using your product are. So I don't know that there's like one answer to that, but what I will do is try to come back with a couple different examples.
And can you just give me an example of what is age gating? So would that be, for example?
So age gating is, when you sign up for a product or service and it requests your birth date before you can use that product, right? And there are different ways to do that. Most companies will employ what's called a neutral age gate. So they will not say, hey, you have to be such and such an age to use this product. They're just asking you your birth date, right? And because COPPA is effectively the law of the land, most websites are designed for and products are designed for people who are over 13, 13 and up. So that's the vast majority of how it works.
Right. So an example would be like if I go to a brewery website and they start with, are you at least 21?
Exactly. Although, yeah, I mean, I think that language would not be a neutral age gate, right? Because it's sending you a clear signal. But yes, conceptually, that's what we're talking about.
Okay. Now, is that required by the actual knowledge? So like or is it only for the,
Well, that's
product?
that's the best way to acquire actual knowledge of how old your customers are, right? Because then you're able to know, if it's a product that's designed for or that allows children under 13, you'll at least know who those folks are, right?
Okay.
COPPA sets out different categories for products, right? There are products that are directed to children. There are general mixed audience, and then there's a general audience product. So, that varies, but yeah, effectively the age gating is the best way to determine how old, to separate your populations.
So general audience product, would that be like, let's say a website that just gives news, right? Like Yahoo homepages. So you don't need to age gate because the news is the news and you're going to read it. Is that?
I think that's fair. Yeah.
Okay.
I think that's fair.
So they wouldn't need to develop an actual knowledge to require someone to opt in for targeted advertising.
I don't know. I'd have to think that through, but I'm not sure right off the top of my head, and I wouldn't want to speak for any particular company here.
Right? Yeah. I should have just said generic generic news website that that has. Okay, great. Well, I don't see any other questions, and I will look for that language that you'll forward. So thank you very much.
All right, appreciate it. Thank you very much, Senator and members of the committee.
Okay, next is John Blair.
So John Blair has not come in yet, so we can just move on to Karen Buckley.
Okay, actually, I did see at one point Chris DeSantis came in. Is he on?
Yes.
Can we, should we go back to him since he was, okay.
Hi, good morning. My name is Chris DeSantis, and I'm an undergraduate student at Yale University. Thank you so much for having me here today. It's an honor and pleasure to testify in support of Senate Bill 6. This bill would improve the privacy and personal information of consumers by protecting consumer data from unwanted sale and dissemination, and increase transparency between businesses and consumers on the use and collection of personal information. Today, I want to offer three main reasons for why these protections are needed. First of all, an increasing number of devices are connected to the internet. Smart thermostats, alarm systems, fitness devices, and other products increase the amount of available data which can be sold and disseminated. As an online presence is increasingly necessary for employment, commerce, and socializing, it seems natural for consumers to have control over the information they reveal online. Although many people value privacy and are aware of data privacy issues, few know how to protect themselves online, and even fewer take action to do so. Research shows that less than 15% of internet users encrypt their communications, and only a third change their passwords regularly. I believe it is important that all Connecticut residents, regardless of background or technological know-how, feel secure online. Secondly, it is imperative for consumers to have some safeguards against data breaches. Admittedly, the consequences of a third party acquiring personal data without consumers' consent are hard to measure, but jarring examples exist. In 2014, the data firm Cambridge Analytica acquired the personal information of 10 million Facebook users to create and sell psychological profiles of American voters, profiles that influenced the 2016 election. In 2021, a T-Mobile breach revealed the information of over 54 million people, including names, driver's license numbers, social security numbers, and device identification numbers for subscribers, former customers, and prospective customers. Although data breaches only result in some reputational damage and bad press for most companies, for the people needing to resecure their accounts, disprove fraud, and face potential identity theft, the consequences loom larger. If consumers face the brunt of these consequences, granting them the right to dictate which information can be made available is a logical choice. Lastly, there is already great precedent for this bill, both in and out of Connecticut. 3 other states, California, Virginia, and Colorado, have passed comprehensive data privacy legislation, and at least 4 other states considered comprehensive privacy bills in committee last year. Moreover, Connecticut is one of the few states with a data privacy unit in the Attorney General's office. The prior experience of Connecticut's Attorney General's office would be important for implementing and enforcing these new rights. Clearly, our state already recognizes the unique need for expanded online privacy protections. We must continue to do so through this bill. As both a high school and college student during the pandemic, I understand firsthand the dependency on online communication for nearly every aspect of daily life. I'm sure many of you here do too. The internet and our online presence is becoming increasingly integral to our personal and professional lives. This is not necessarily a bad thing. The ease, efficiency, and accessibility of online communication and commerce provides resources and opportunities for people which they otherwise would not have. I'm even testifying for the first time online. But with no comprehensive national data privacy legislation, states like Connecticut must set a strong example and define this emerging issue. I urge you to favorably vote this bill out of the General Law Committee so that all Connecticut residents can feel their personal information is protected. Thank you.
Thank you very much, Mr. DeSantis. Does anyone have questions? If not, I guess I have, well, just thank you for testifying. Thank you for your participation in some of the working group meetings. And I think you brought up a couple excellent points, right? That as we move to the Internet of Things, where more devices are connected, there is just our digital footprint gets even bigger, right? And the fact that during the pandemic, we were all forced online for better or for worse. I think there are some good positives that have come. Right now, you're able to testify without having to go all the way up to Hartford. So I think that it's made it more accessible, but also I think it is good for people to think about how their data is being used. And sometimes we do things for awareness, right? I think the awareness this legislation brings will be just as, sometimes that could be almost as effective as what you actually legislate. So thank you very much. I guess, given the fact that I'm of a different generation than you, my reunion this year will be many years more than before you were born. So is data privacy something that you would say is more important generationally? Is that something that you would say that students find more important or paying more attention to?
Yeah, I think there is a growing importance, or at least a concern, for data privacy generationally, since so much of our lives as young people exists online. I communicate with all my friends through different websites and social media applications, and I do most of my shopping online. And I've even done some of the most formative years of my education, my senior year of high school and my first year of college, portions online. And I think that's just a function of how the trend that the world is going to, and the time that I was born in. We're sort of moving out of one place in our relationship with the internet and technology and heading in another direction, as you mentioned, with the Internet of Things and devices on our wrists being able to track our biometric data and tell us all this information about how to lead healthier lives and what foods we should be consuming. So I think as we enter this new sort of era of our relationship with technology and the internet, it's important that we extend a lot of the fundamental rights that we have for sort of physical commerce and interaction between people to this digital space. And I think this bill is a really good first step in that direction.
And thank you for bringing up that point. I think it's a good point. It's just extending other rights. And in many ways, it's a right to know, right? Just to know what data is being collected about you. So seems like a fundamental right. So does anyone else have a question for Mr. DeSantis? Okay, if not, thank you very much for your testimony. Okay, Mr. Clerk, I believe next we have Karen Buckley from the Connecticut Hospital Association.
So John Blair just came in.
Karen, Ms. Buckley, I'm so sorry. You keep getting that.
Karen can go first. I don't want to do that. After Karen, if you'd like to go, Karen.
All right, thank you. Ms. Buckley, would you proceed?
Thanks, John. Good afternoon, Senator Mahoney, Representative D'Agostino, Senator Whitcoast, Representative Rutigliano, and members of the General Law Committee. I'm Karen Buckley. I'm the Vice President of Advocacy for the Connecticut Hospital Association. and I'm here to testify on Senate Bill 6. In the interest of time, I'm going to summarize our concerns and point you to our detailed testimony, which not only highlights the concerns, but also provides substitute language to help resolve the issues we've identified. CHA supports the concept of the bill, but believes the bill requires modifications to avoid significant unintended consequences that would negatively impact Connecticut and our fight to address healthcare disparities. As you know, in 2021, Connecticut officially recognized racism as a public health crisis. To best combat health disparities, it's going to require a lot of hard work, the use of data, and sophisticated data analytics. While we understand that Senate Bill 6 tries to balance important consumer protections with the need to avoid interfering with legitimate data uses through those exemptions, these exemptions fall short for healthcare. The current entity level exemption for healthcare entities lists only hospitals as exempt, which immediately disregards systems, pediatric practices, physician offices, surgery centers, and many nursing homes, as well as other healthcare providers. While there is a HIPAA exemption for data covered by HIPAA rules, the exemption is not broad enough because it fails to encompass data that is sourced from outside the patient record. This is a critical gap. If this bill were in place during the COVID-19 public health emergency, the inability to collect and exchange data outside of the patient record would have stalled, if not blocked, the ability of providers to determine where COVID-19 testing and vaccinations were most needed and which populations were being underserved. The draft bill currently contains an exemption for public health, which in this case is a legal term defined in federal law as exclusively relating to activities only when an official public health authority is involved, like DPH. This exemption does not expressly cover population health and community health activities of providers or others outside of government. Even though we all know that population health and community health have long been recognized as necessary for addressing healthcare disparities, such as food and housing insecurity. While the bill does exempt 501c3 nonprofit entities, it should also exempt 501c6 nonprofits and other similar entities. Addressing racism as a public health crisis requires broad engagement, all hands on deck, by as many willing entities as possible, not just 501c3s. We further request a modification would be for the bill to provide an express exemption covering Connecticut's patient safety organization law, and it should provide a clear and express exemption for third parties that perform data storage and co-location services, but that do not directly use the data. Finally, we would ask that the Office of Attorney General would set up and operate a unit to offer timely technical assistance to answer questions that businesses have as they prepare for implementation of this new law. We thank you for the consideration of our position. We urge you to make the requested changes so that Connecticut continue to move forward in this important work, not backwards. I'm happy to answer any questions.
Great. Thank you very much. Do any members of the committee have questions? I just, again, we discussed this yesterday. I do want to push back slightly on the, the issue that it would have hampered our abilities to have fought the pandemic, in that, we do have the public health exemption. There is a data protection law in California. California, they did use data for, for their vaccine outreach as well. So, and their law is more restrictive than ours will be. But the point is well taken that, it's an unintended consequence that if we can, we'd like to avoid. That if we do need to expand the definition of public health, or not expand, but correct the definition to include community health, that is something we definitely should do as we look for the social determinants. We did have testimony earlier. I'm not sure if you were listening when Find Help, which is one of the closed loop referral systems, that they didn't feel that this would hampers their ability. If anything, they had advocated for stronger data protections. So, and then the other is, I know that, the other states do not, we give the entity level exemption to hospitals. They do not give entity level exemption. I don't believe they do that in Colorado or in California. And they also do not give the entity level exemption to HIPAA entities. I understand that, you know, you'd point out they have medical records laws that we do not have. So I do need to look into that. But I think our goals are the same. So we just need to ensure that we're looking at that language around the population health, right? And so that's, you know, we don't adversely impact that important work.
Right. I think a couple of things, if I can. It's important to note that Connecticut's response to COVID-19, both for vaccinations and testing and other response in Connecticut, was very different than other states. We didn't experience people waiting in ambulances outside EDs, waiting for care, or a lack of beds. We had high vaccination rates that you don't see in other parts of the country. And that is in large part because of, quite frankly, the tremendous work that hospitals did. And they didn't necessarily do that at the direction or on behalf of the public health entity. They did it in partnership with the state. So that is the distinction when you look at the definition of public health. In this language, it would require it to be done, if you will, under the guise or the umbrella of the public health authority. So it's not just public health work. It is a specific legal term, and that's why we're looking to broaden it to include community health and population health, because the work that we did was to look at the underserved areas. Where should we be sending our vaccination vans? Where should we be sending the clinics, setting up our clinics and testing? That was not done at the direction or under the umbrella of DPH all the time. We had a tremendous partnership with the state, without a doubt. But it would have limited our ability to respond the way we did. And we would encourage you to make that change. In reference to the closed loop referral system, it is without a doubt a priority of hospitals and the Hospital Association to start to look at and address social influencers of health. And part of that is a closed referral system. That is, if you come into the ED and we refer you to a community care team or use the systems that are currently in place to address all of your needs, the whole needs, whether you have housing, you have food, you have transportation, you have other needs that need to be met. The way to do that is through a closed referral system, so that we know that when we're making a referral to send Karen Buckley out for help for food insecurity, that there's a loop back to make sure Karen is getting that help. If you do not include people or entities throughout the system or providers such as physicians as part of that, it limits the ability of being able to share that information because it's not public health or health data. Right? We are clear on the HIPAA exemptions. HIPAA exemptions are in place and the rules are in place for the work that we do. And that's true in the closed loop referral system. We have to abide by HIPAA. But this would limit our ability to share information with our community partners to address the very needs that we were charged with addressing last year through the legislature. And then finally, on the medical records piece, and the other states, it's clear to us, I know you've talked about California and Colorado, they do have different rules in place for medical records. Virginia has actually looked at this and added in the exemptions that we requested because they see it as a weakness in the other states. And we know that this is part of an ongoing conversation with you, and we welcome the opportunity to continue to talk with you about it. But we think that the things that we've requested in the bill today are essential to make sure that we can continue our commitment to the public in Connecticut and to looking at the issues of health equity and addressing them. I think I got all the things that you brought up, but if I missed one, you can let me know.
Yeah, I do want to circle back because I'm trying to understand how this would prohibit a closed loop referral. So do you do a referral without asking the patient now? Like
No.
Someone comes in, because this is, the bill just establishes opt-out rights, meaning that you would only, it's not even that they would have to opt in, although that may be sensitive data, so maybe it would be opt-in, but do you get permission from the patient to make a referral?
Right, so the issue is, if you will, the looping back, right? So we do get the consent of sharing information from patients, but it is the looping back of what information can be shared. So it'd be like, we only got half of the information, not all of the information on the patient, which, as we all know, is not helpful to solving the patient needs. The same thing can be true for the issue I raised about whether it's only 501c3, because on our community care teams, which get permission to share information, they're not all 501c3s. There are community partners who help to solve the issues for patients who come into EDs over and over again, because they're not coming for health issues, they're coming for social influencers or social determinant issues. And this would limit our ability to have that communication and have the loop come back to us without having this exemption in place. And I'm happy to kind of take that off the line and explain,
Yeah,
go into
I
detail.
think we're going to need to, because I'm having trouble understanding, given the fact that, Find Help, which is a large closed loop referral, has stated it wouldn't inhibit their ability. You're getting the permission from the patient to make the referral. I don't see where our protections, and you're saying so it prohibits the information from coming back to you, but I don't see that, but I'm not, again, I'm willing to, we should have that conversation, because it's not the intent to prohibit that. If there is in some way, it is, because it's not intended, and it doesn't, Find Help is doing work in California now, and it's not inhibiting their ability to do the work out there. So I don't.
Right. And so I think the distinction, and we can go into this further offline, is about the type of data, right? So Aunt Bertha talks about following HIPAA rules. We're all following HIPAA rules and what information can be shared. But not all of the information in this closed loop referral system is actually PHI, right? There are other pieces of information that come, and that's where you're setting up basically two different standards, right? So it's hard to have, if you don't have all the information in place to meet the needs of the patient, which is what we're trying to address. So we're happy to talk about that, because without a doubt, we're following HIPAA rules and that sharing of information, but it's really a different type of data set. And right now, what you propose is that those data sets are not complete, for lack of a better way of saying it.
Okay. And that's what I guess given the fact, like I said, it's existing as a complete data set out in California, I don't understand that. So we're going to have to probably take some more time offline.
Okay. Happy to do that.
Okay.
Appreciate the opportunity to discuss it.
Thank you. Are there any other questions? Okay. Hearing none, thank you for your testimony, Ms. Buckley.
Thank you.
So we'll, Mr. Clerk, I believe John Blair is up.
Thank you. Hello, Senator Mahoney. Good afternoon, everybody. Good afternoon, chairs and ranking members of the General Law Committee. Thank you for the opportunity to testify today. My name is John Blair. I'm here on behalf of CBIA, which you know is one of the largest business organizations in the state, and we represent a diverse cross-section of members, and we have 95% of our members are small businesses, less than 100 people. So I'm here today to comment on Senate Bill 6, not to oppose it, just to kind of pass along some cautionary comments as you continue to work through the bill. I'd like to first recognize Senator Mahoney, as others have, for his continued commitment to this legislation. He's made every effort to make sure that all the voices have been heard. He's invited experts from across the country to provide suggestions, and has allowed for all sides to be considered to come to a final conclusion of a well-functioning Connecticut dated privacy bill. We believe that there is an opportunity to draft a proposal that properly weighs the rights of consumers against the businesses. As we continue to emerge from the pandemic, CBIA has encouraged legislation that helps keep costs down for struggling businesses. This session, we've emphasized small business relief, including not adding costs to their bottom line. If this legislation is overly aggressive or not drafted carefully, there are legitimate concerns about the negative financial impact on small businesses. This runs counter to what our small businesses need at this time. Over the summer and fall, our members met with the working group that Senator Mahoney headed to review options for a Connecticut privacy law. Those communications, as we've heard today, are ongoing, and we would urge the members of the legislature to continue until an agreement can be reached by all parties, which is, I understand, is not an easy task. Small businesses in other states, as has been discussed, have been impacted negatively by the passage of these laws. The laws added millions of dollars in substantial initial and ongoing compliance costs. In California, I know the estimates are a bit dated. I'll just say that they were in the billions for initial compliance. It was also in the billions for direct compliance costs by 2030. Even if you cut those numbers in half, they still are concerning. Lastly, we understand the passage of a Federal Privacy Act is not currently on the table. However, a federal act would be the best remedy. The passage of data privacy laws on a state-by-state basis, as opposed to a uniform federal act, creates confusion, resulting in costly and cumbersome processes for many multi-state businesses. The three comprehensive level privacy laws passed are all unique. Thus, multi-state organizations must comply with a different set of rules depending on where they're doing business. The best approach would be a federal law. In closing, I would encourage legislative leaders and members to take a balanced approach, properly weighing consumer privacy rights, which are omni-important, against keeping the cost of doing business down. I thank you for your time today, and I'd be happy to answer any of your questions.
Great, thank you very much. Let me see if any of the members of the committee. I don't see any questions. I guess I'll just state that we're never going to get everyone to agree on this. We're trying to work, and as you know, with all legislation, there comes a point where you have to make decisions, and unfortunately, sometimes people view there are winners and losers. I don't necessarily always think that, but we have to, I guess, bargain in good faith to come to an agreement which involves some give and take, and I don't know when there will ever be a good time for doing it. There's never a right time, I don't think, for some of these things. But thank you very much for coming and for expressing your concerns.
And Senator Mahoney, I do want to thank you. Look, I understand what you said, and I know it's not hard to get everybody on board with this large of a piece of legislation. It impacts a lot of different businesses in our communities, and I think if you continue to listen to everybody and keeping your doors open, it's a testament to your work. So thanks.
Okay, thank you. All right, Mr. Clerk, we have Olivia Rinkus.
So Olivia has not been on yet, so we can just move on to our last person, Art Corey.
Okay, thank you.
Good afternoon, Chairman Mahoney, Chairman D'Agostino, ranking members Witkos and Ritigliano, and other members of the committee. I'm Art Corey, General Counsel with the Connecticut Bankers Association, and we very much appreciate the opportunity to talk to you about Senate Bill 6 today. By way of background, the CBA represents banks of all sizes and charter types, from the largest national banks to smaller state chartered community banks operating here in Connecticut. Before talking substantively about Senate Bill 6, we want to thank and recognize Senator Mahoney and the committee for what has been an inclusive approach on this important legislation. We think that approach will certainly end up in a fairer bill. We'd also specifically like to thank you for your consideration and work on an exemption from the bill for financial institutions and data that are subject to the consumer privacy and information security rules of, and I know we're all tired of hearing this, the Gramm-Leach-Bliley Act. You've already heard a lot about the GLBA, but I also wanted to note with regard to banks is that in addition to the expectation that banks comply with the GLBA, they are also regularly examined by their regulators, both state and federal, for compliance with the GLBA. Keeping customer information private and safe is a top priority for financial institutions. They know that, like protecting their customers' funds, protecting a customer's information is also incredibly important. The adoption of the GLBA and its privacy rules over 20 years ago only fortified banks' efforts in that regard and fostered better consumer understanding of how financial institutions use and protect their information. We believe that exempting financial institutions subject to GLBA from state privacy laws, as Virginia and Colorado have recently done, will avoid unnecessary overlaps and conflicting requirements that could result in confusion for both financial institutions and their customers. We thank you again for your consideration of our comments and the exemption, and look forward to working with the committee as Senate Bill 6 moves through the legislative process.
Great. Thank you very much for your testimony. Does anyone on the committee have a question for Mr. Corey? So hearing none, thank you very much
You're welcome. Thank you.
for taking the time to come testify.
Of course, thank you.
Mr. Clerk, is there anyone else who would like to testify?
Nope, that is it.
Okay, I guess then that brings our public hearing to a conclusion. I see Co-Chair D'Agostino. I don't know if you had any comments.
Just to thank you, James. You took the labor in order today. I will do the same on Tuesday. And for committee members, the plan is for a public hearing on Tuesday, the 8th, to be our last public hearing for the year, and then move into JFS.
Great. Thank you very much. Senator Whitcomb?
No, thank you for all your work and on not only on the bill, but in today's hearing. And we heard a lot of good input. So thank you. Looking forward to discussing further.
Thank you. And then Representative Vitigliano?
I am here, and I did really enjoy listening to everybody today and getting more informed on the bill. So thank you, Senator.
Thank you. All right. So with that, I believe we are adjourned. Thank you very much and have a great day.
Thank you.